I extend a very warm and healthy welcome to all the participants and learned speakers to the 76th webinar on insolvency law, issues, challenges, and road ahead, being organized by Corporate Professional as a part of its knowledge sharing initiative. As you are aware, respected dignitaries, that since beginning of the COVID, we have started this journey, and now we have completed the golden jubilee. We have completed 75th webinar, which we have organized last week, and this is 76, and we are continuing this particular knowledge sharing initiative with the help of regulator, help of professionals and participants. Our special thanks today and very warm welcome to Chief Guest Dr. Navrin Saini and all our guests of honor, Dr. Muklita Vijayvargiya, Mr. Amit Pradhan, who despite their hectic schedule and they have joined us today to enlighten us on the current thinking of the government and the regulator and the way forward towards achieving the objective of the Insolvency Code. The Insolvency Code, Insolvency and Bankruptcy Code, enacted in 2016, is one of the deepest financial sector reforms of the last decade. From the day of its enforcement, IBC has been continuously reviewed towards achieving its object of time-bound resolution and stress asset while maximizing their value, promoting entrepreneurship, availability of credit, and balancing the interests of all the stakeholders. The Insolvency Law Committee also in its report proposed various changes, enabling a swift admission process, streamlining avoidance, transaction and wrongful trading, time period of resolution plan, closure of voluntary liquidation process, and IBC Fund. Various issues they have discussed. And recently, Hon'ble Finance Minister in her budget speech also stated that necessary amendment will be carried out in IBC to enhance the efficiency of the resolution process and facilitate cross-border insolvency resolution. And further, the Center for Processing Accelerating Corporate Exit, the CPACE, with process of re-engineering will be established to facilitate and speed up the voluntary winding up the companies from the current required 2 years to less than 6 months. That was a budget commitment to the Parliament by the Finance Ministry. A very notable and path-breaking amendment made last year was the introduction of pre-pack insolvency resolution. The objective of the webinar is to understand the contemporaneous of the subjects and discuss the issues and challenges and what is the future path for the regulators from the regulator side. Our galaxy of speakers have also been kindly agreed to take the queries of the participants also. So before I invite our chief guest and guest of honor, I just introduce, and it is my privilege to introduce our guests. First, Dr. Navrin Saini, who took charge of as a whole-time member of Insolvency and Bankruptcy Board of India on 31st March 2017. He has held the additional charge of chairperson IBBI from 13th October 2021 to 9th February 2022. He is a postgraduate in management and law with PhD in corporate law and also qualified company secretary. Dr. Saini has served the Ministry of Corporate Affairs in various capacities and held the highest position of ICLS as a Director General of Corporate Affairs in the rank of Additional Secretary. He also served as a commissioned officer in Territorial Army from 1985 to 2011 and superannuated as Lieutenant Colonel. He's our old known friend, so I know this, but this is for all the participants that he is superannuated as Lieutenant Colonel. And during his tenure, he was in ROC and then MCA 21 came, so he was a main pillar to implement this. He is keen mountaineer, trekkers, and a skydiver, and I'm fortunate to go for mountaineer with him 1 and 2 times. He is presently looking after registration and monitoring wing of IBBI. In addition, he is in charge of legal affairs and division and establishment division. I welcome Dr. Saini for this program. Then we have Dr. Muklita Vijayvargiya, is whole-time member IBBI and also a member of Executive Committee of International Association and Insolvency Regulator. She has more than 40 years of experience in legal field in various capacities as an advocate, law teacher, researcher, guide to PhD scholars, law officer, civil servant as a member of the Indian Legal Services (ILS), visiting scholars in Japan and Australia. Prior to joining to IBY, she was Additional Secretary in Ministry of Law and Justice and Course Director in Institute of Legislative Drafting and Research. She has been a member of various expert group, advisory committee and drafting committees, including Bankruptcy Law Reforms Committee, BRRSC, which recommended the framework of Insolvency and Bankruptcy Code 2016. I welcome, and we all welcome you, Madam, for this program, and will definitely benefit by your experience and knowledge. Then we have Mr. Amit Pradhan. Amit Pradhan is Executive Director, Insolvency and Bankruptcy Board of India. Immediately after joining IBBI, he was serving as a Chief General Manager and Adjudicating Officer in SEBI. He has been with SEBI since 1997 and one of the old pillar of SEBI, and has been serving in various capacity in different departments, including as Regional Director of the Northern Regional Office of SEBI in Delhi. He was also served as an advisor in the Competition Commission of India. He was a member of Bankruptcy Law Reforms Committee, which conceptualized the Insolvency Code, and today he is here as a Executive Director in Insolvency Board. We welcome you, sir, and we will definitely get the benefit from your expert knowledge and your experience. So, friends, other than this, we have our professional, that Amit Gupta, who is a PCS Insolvency Professional, and then we have Mr. GP Madan, who is Founder and Law Office of Chairman NCLT and IBC Committee of PSD CCI. Then we have Mr. Manoj Kumar. He's a partner and head M&A and transaction advisory in corporate profession. And then we have a Karan Gandhi, associate partner in corporate profession. So I welcome all the dignitaries and our expert speakers. And before requesting Dr. Saini, I will just tell you the program structure. First, all our three dignitaries will speak. First, Dr. Navrang Saini, then Mukhlita Madam, and then Amit Pradhan sir will speak. And they will give their views on issues, challenges, and road ahead. And after that, we will request them that they can take up some questions on public, because Dr. Saini has their meeting and then everybody is busy. So I will request they can continue, but if they have some other engagement after the public's question, they can do, and then we will start question answer from our expert panel. Before doing this, we want to inform you that we have came out our insolvency book that we will release after the Dr. Saini's introduction. So I will request Dr. Saini, please say the something which regulator is doing and they want to do, and they want what they want from the professional as well as corporate. Dr. Saini, please.
Thank you, Pawanji, and thank you for what you can say, the detailed introduction of mine, and specifically with the MCA 21. Let me tell you, Pawanji was also a great, there is a word, stimulator. So he was a persuader of computerization in ROC office, and we had lot of discussion for initial computerization in of the ROCs, and of course we have great outings also, of course, for the professional programs. So thank you very much, Pawanji, for introducing. And Amit Gupta ji, Madan ji, Manoj Kumar ji, Karan Gandhi ji, my colleague Dr. Mukhlita Vijayvargiya, Amit Pradhan ji, and participants of this webinar. Good evening to all of you. It's indeed a pleasure speaking in 76th webinar on insolvency law, issues, challenges, and the road ahead, organized by corporate professionals as part of its knowledge sharing initiatives. Pawanji has been organizing these programs. He has been coming out with various publications also for the benefit of the professionals. We can see from the number, it's 76. So he has already organized 75 webinars. So this shows his passion for knowledge sharing, or I can use the word dissemination of the knowledge, because education is always to share. One should not keep the knowledge with him. It should always be shared with others. Of course, professional secrets are there. Madanji is actually looking towards me. So professional secrets, you can say, of course, that cannot be shared. But knowledge, yes, legal knowledge you can share. Legal tricks or whatever trade of the tricks may not be shared, but it's always good to disseminate the knowledge. I am of the view, some may not agree with me, but yes, I have been as a student also, and sometimes as a teacher also, I have been sharing whatever I am knowing. So coming on to the topic, as stated by Pawanji, IBC 2016 is one of the deepest financial sector reforms of the last decade. One of the most remarkable achievements of the code has been the significant behavioral changes that it has effectuated or nudged among the debtors and creditors alike. This behavioral shift has resulted in substantial recoveries for creditors outside the code and improved the performance of firms. It is further motivating them to make the best efforts to avoid default. It encourages the debtor to settle default with the creditors at the earliest, preferably outside the code. With the code in place, non-repayment of loan is no more an option, and ownership of the firm is no more a divine right, and equity is no more the only route to own a firm. The code has had an impact on the credit market. From the day of its enforcement, Insolvency and Bankruptcy Code has been continuously reviewed towards achieving its objective of time-bound resolution of stressed assets while maximizing their value, promoting entrepreneurship, availability of credit, and balancing the interests of all the stakeholders. So far, 6 amendments have been carried out in the code. Insolvency and Bankruptcy Board of India has issued 18 principal regulations, and a total 62 amendments has been carried out in regulations. So you can see how basically you may use the word proactive or swift in actually bringing the procedural law in place at the time of the need. The Ministry of Corporate Affairs has floated a discussion paper on 23rd December 2021 and has invited comments from the public on proposed changes to the corporate insolvency resolution and liquidation framework under IBC 2016. Proposed further changes include enabling a swift admission process, streamlining avoidable transactions and wrongful trading, time period of resolution plan, closure of voluntary liquidation process, and IBC Fund. Time, of course, as well as admission are the issues, and I think the learned speakers will be discussing on all these issues. On the time, even the Honorable Apex Court has given its judgments. Way forward, if we actually talk about the way forward, this includes the operationalization of individual insolvency, amendment relating to cross-border insolvency under the code. Pawanji, you will excuse me. Actually, there is another seminar going on. So another meeting is going on. So I'll be very brief. And with these few words, I would like to thank Team Corporate Professionals for organizing this webinar and with success and fruitful discussion on issues, challenges, and road ahead. I would also like to thank Pawanji for coming out with latest edition of the book on insolvency law. Thank you very much. Thank you.
Sir, just I want 2 minutes from you. I want to release the book from your gracious hand. So please, we have book with us. Madam, I will request Amitji, please take out your book also. and all other learned speaker will get their book, this book. So for your gracious hand, Madam Navrang Seni sir and Amit Pradhan sir, please release this book, which is just show this. Yeah. So this is the, yes. So Vivek, yes. So this is our third, and Dr. Seni has written the foreword for this book, and I will not just within 2 minutes. I'll just explain about this uniqueness of this book. So, sir, it will be useful for everybody that they can see. This is a compendium of insolvency and bankruptcy book, and this book contains various innovative features, which you can see the text of the section, date on which the section is enforced, relevant notification, rules, regulation, and case law, and referred provision, other law. It is just behind the section which is connected. Like this will be the summary will come, that amendment, which is the date, requirement amendment, regulation number, and the section referred. And after that, it is talking about that this is the section 3. So the Insolvency and Bankruptcy Application and Adjudication Authority rules that will come under this 3C, which is connected to this. And then you will see the next part is next page, the 10A. So in 10A, this is the point, and this is the notification which is connected to 7, 9, 10 that are connected to 10A that will come next. And this is the management affair of the corporate debtor interim resolution. And then case law. So this is case law, this subsection 1 and part B. So the case law is connected to this B section. So you will find the gist here. Next, that this particular is font 2E, and that is the relevant law is there. So you can read this. So these are the key feature, and some of the feature is overview of the code, procedure under the code, enforcement status of the code, quick ready referencer like gist of decided case, offenses, penalties, list of special code and NCLT. And we have given procedure under this code of each and everything relating to procedure for initiating corporate insolvency. What is the section, rules, form, approvals, who will give the approval, and then important provision and prerequisites is there. And then procedure is also there. What is the first part, forms document, which is required, governing law, steps which you have to follow, and what are the documents required, that is also there, the complete list. And then enforcement status of the code. So the detail is there in which date, which law is applicable. So the complete date is there. Section 1 is applicable from 28th May 16, clause 1B to 1st December 16, then clause F and G of section 2 is not yet enforced, so that you will get this information. Then you will get the decided case in the crisp manner. So all the cases of Supreme Court that you can find here, offenses and penalties, and what are the section in this that you will get. This is the section and this is the penalty. So this is the beauty of this book which we have come out. Then under one you will get each and everything here, and the Karan, Manoj, and Karan's team, they have done the work on this, and B.K. Agrawal ji and Shivam Singhal, they are the behind this. So thank you, Dr. Seni. Thank you very much. If your meeting is over, please join us. We will be happy because there are some questions which public is asking that you can give. Thank you very much.
Thank you. Thank you, Pawanji. Ma'am is there. I think she can answer any question, maybe on the legal side or maybe on the IBC side. So she is an expert of all the things because everything flows from the law. और फिर मदान जी बैठे हैं, देखिए हमारे प्रधान साहब बैठे हैं, so they will be able to answer. And thank you very much. Thank you for inviting.
Yes, sir.
Thank you.
Okay, now, Madam, because you were the part and parcel of this particular journey of this law, not only from its inception but from this concealment. So you were there in the legal ministry, and you have done this. So we want to take up your view because your thought process in the future is very important. Over to you, Madam.
Thank you, Mr. Pawan Kumar ji. And I thank corporate professionals for organizing seminar, and I thank Pawan Kumar Vijayji for inviting me, especially inviting for this seminar. Now, respected our chairperson, Dr. Narayan Saniji, Mr. GP Madanji, Mr. Karan Gandhiji, Mr. Manoj Kumarji, Mr. Amit Guptaji, and Shivam Singham, and other participants and stakeholders present in this webinar. We all have witnessed 5 years of journey, more than 5 years of journey of Insolvency Bankruptcy Code. Truly, this code, which has been enacted on the recommendation of the BRC committee, where I also participated in the deliberations, I think it is the first enactment which has laid down the it is the first enactment which has laid down the history of procedural reforms. मैं सही शब्द में कुछ एक छोटा सा एग्जांपल देके आज बताना चाहती हूँ कि इसका इंपॉर्टेंस क्यों है. आटे से पूड़ी बनती, पराठा बनता है, रोटी बनती है, but the procedure is different. So you have a different taste. So if we change the procedure, certainly we can make our dish tasty, delicious. And similarly, in case of enactment of law also, if you want to solve any problem, maybe a welfare scheme, maybe a regulatory law, we don't know. But in any case, if we change the procedure, we were having the procedure debt in possession method, but we could not achieve the desired result, and still the new problems emerged with every enactment. What I say is that with every enactment or every statute, you find more and more litigation. So litigation means, enactment means generation of litigation. This is the first law where we find that it is meant for the resolution, not for litigation. Though we witness that there are a number of litigations which have emerged because of this resolution process. Maybe in times to come, those loopholes or gaps will be filled up. But every stakeholder, every participant, maybe professional, maybe valuer, maybe IP, or maybe other auditors, if they work with the intent to resolve, maybe the COC members, if they participate in a different way, certainly we can make this law a successful law and a model law, maybe more than unsettled model law. Maybe this our law may become an unsettled model law, and other countries may follow it. So this law is very important, and it has effective because we have seen behavioral changes in the market, maybe in the form of opposition, or maybe in the form of that they are withdrawing, or they are changing their behavior, they're not taking loan or repaying in time. So that is a behavioral change, and that is success of every law. The purpose of every law is to change the behavioral pattern, because with the particular behavioral pattern of a market, sometimes there are mischiefs, there are many events emerging out of it. So certainly law is enacted that you change your behavior. Law is enacted that you drive a car with license, or you walk on the left side of the road. So law expects that whatever method of fashion of behavior we want, we have written in the provisions. That is it. Here the success of law is that the people have started withdrawing. There are a number of applications filed, but because of the inadequate structure, naturally admission is lesser number, but still after filing we see number of thousands of applications have been withdrawn. That is a behavioral change or sea change. Now I find that in the global community, there are 3 things: ease of governance, ease of living, and ease of doing business. I think all the laws are enacted primarily for all these 3 purposes. Ultimately, their purpose is the ease of governance. If you bring to have a transparent, accountable governance, we have RTI, we have Information Technology Act, we have a number of other schemes and executive directions there. Ease of living. For ease of living, certainly constitutes a number of rights and duties, no doubt. But the informed decisions, if a citizen has an informed decision, he wants an informed decision, then we have to have an RTI. And with the enactment of RTI and other constitutional provisions, welfare schemes of the government, we have ease of living. और रोज ही कुछ ease of living के लिए कुछ ना कुछ और declaration government कर रही है. That's ease of living. आयुष्मान योजना हो या मुद्रा योजना हो या कर्ज के बारे में है, स्टार्टअप प्रोग्राम्स हैं, ये सब ease of living के लिए हैं. And ultimately, every aim of governance and doing business is also ease of living of the individuals. Now, ease of doing business. There are many number of statutes regulating commercial activities of number of entities, maybe company, maybe LP, maybe MSMEs, and ease of doing business. I think for the purpose of ease of doing business since 1990, लिवरेज इकोनॉमी पॉलिसी से बहुत सारे द्वार ओपन कर दिए, WTO आया, बहुत कुछ हुआ, ease of doing business के क्या, और for the purpose of ease of doing business, what we notice, a single window clearance system has been the strategy everywhere in the world. कि एक खिड़की पे आएंगे और आप सब काम कर लीजिए, single window clearance, centralized registry has to be there इन सब purpose के लिए. Now you'll find that under this code also, like a single window clearance, under this code also we find that there are provisions for CRP for corporate, for individuals, for MSMEs, we have provisions for professionals, then we have provisions for frontline regulator like IPA, then we have registry for this record of defaults also, IU. So we find that all the provisions are together in one, and you will be surprised that we have UPSC for examination, but in case of IPs, we have universities for LLB examination, we have other universities for medical examinations, entrance examination, but for the purpose of IP, that is also conducted by IBBI. So under one single umbrella, you find number of service providers of different nature, but the regulator is same. And within a period of 5 years, certainly there has been a lot of progress. We have come to this extent that now we are on the verge of enacting cross-border insolvency. I think after the enactment of the provisions related to the cross-border insolvency, maybe through another separate act or any additional chapter in this very code, but I think the whole process will be complete. जैसे हम कहते हैं कि आप तिलक और बिंदी लगा दिया या माला पहना दिया या हम कहते हैं आरती कर दिया है, तो cross-border insolvency जो आएगा वो एक तरह से आरती होगा कि पूरा ही हो गया है कॉर्पोरेट वाला सेक्टर. और ग्लोबलाइज वर्ल्ड में, जहाँ ग्लोबलाइज वर्ल्ड है, जहाँ प्रॉब्लम्स ग्लोबलाइज हैं, वहां पे क्रॉस बॉर्डर इंसल्वेंसी असेट्स हमारे दूसरे कंट्रीज में है, कनेक्टिविटी और ये ग्लोबलाइज्ड वर्ल्ड का जो एक सिस्टम बना है, वहां पर कोई भी कानून, कोई भी स्टैच्यू बने, हमने ड्यूअल सिटीजनशिप दे दी हमारे इंडियंस को, देखिए ना आप, तो जो क्रॉस बॉर्डर के जो इश्यूज हैं वो यदि चैप्टर आ जाएगा, कंसल्टेशन पेपर आ गया है, आई होप very soon we will have cross-border insolvency provisions, and then that will complete. But before that, before the notification of the insolvency, cross-border insolvency provisions, certain things are required. In my opinion, whenever an act is enacted, there are 3 things through which we can make any law very successful. Pre-awareness of the enactment. आप enactment कर रहे हैं, उसका awareness लाइए, pre-awareness. So mindset हट जाए. जब हमारा liberalized policy आया था, I think mindset was not prepared for that. We took so many years. हमने उसको आत्मसात करने में बड़े दिन लगा दिए, और शायद हमने डेवलपमेंट का जो स्पीड होना चाहिए, it was not that much. जो अभी हम नोटिस कर रहे हैं, वो शायद बहुत पहले हो जाता. प्री अवेयरनेस होना चाहिए. आफ्टर इम्प्लीमेंटेशन, इम्प्लीमेंट कर दिया, नोटिफाई कर दिया, नोटिफाई करने के बाद में फिर हमें देखना होगा इसमें कि क्या क्या प्रॉब्लम्स आ रही हैं. अब फॉर ईज ऑफ इम्प्लीमेंटिंग द प्रोविजंस, certainly we require customer care like help desk in every institution, because for small things, if we approach the NCLT, or small things, if we approach the courts, maybe Supreme Court, in case of IBC, NCLT and Supreme Court, then they are overburdened. Lot of time is consumed. आप एक चीज पूछिएगा उनसे, एक एप्लीकेशन सिंपल से लगाइए, पर वहां पर ढेर लगे हुए हैं, आपका नंबर कब आएगा? ऐसा एप्लीकेशन तो नहीं, हिजाब वाला एप्लीकेशन को ऐसा एप्लीकेशन हुआ जो एक पब्लिक कंसर्न का है कि उसको एकदम रात सुनेंगे हम लोग, ऐसा तो नहीं होता है. तो आप ये देखेंगे कि यदि हर इंस्टीट्यूशन में, because under this code we find that it is an institutionalized mechanism, professional driven mechanism, technology has been infused with the process. So certainly the process is very robust process for compliance and disclosure mechanism, but still we find that we cannot capture every situation of the corporate or every problem of the corporate within our legal formulation. It requires best practice. It requires some kind of advice or some kind of counseling. It's not a diagnostic method. कि एक diagnostic में आपका आया बीपी इतना हो गया है, या आपका ऑक्सीजन नीचे चला गया है, या आपका जो ब्लड के टेस्ट होते हैं उससे पता लग जाता है और हम खुद भी कह देते हैं कि इसको ये चीज दे दीजिए. It's not like that. We can't prescribe for every mischief or for every kind of evil or every kind of problem, but through law. Certainly it has to be dealt. And that is why this process is professionally driven. But still I find that there are certain problems, and in case of corporates, if we have, the problem is regarding the maximization of the value of the assets. Delay will deteriorate the value. These are the two parameters. Delay will deteriorate, and we need to maximize the value. How to do it? So we have to have a lesser time bound. Time bound is there, professional is there, and then we expect maximization. But what is the bottleneck? We can't have the, what is the bottleneck? Why can't we have, why is so much of a haircut? And that's I was thinking, कि if जैसे हम लोग हर आदमी के कहते हैं हर साल चेकअप कराना चाहिए, बॉडी चेकअप, एवरी ईयर वी शुड हैव अ बॉडी चेकअप, तो क्या हम बॉडी चेकअप प्रोफेशनल का कॉर्पोरेट का नहीं करा सकते? हर साल होता है, ऑडिट होता है, but I think something more than audit is required. Something more than audit is required कि एक कॉर्पोरेट का हेल्थ चेकअप हो जाए, अर्ली वार्निंग आ जाए कि इंसॉल्वेंसी में जाएगी, या उसके पहले हम उसको संभाल सकते हैं. हालांकि हमारे इंसॉल्वेंसी कोड में उसके पहले संभालने के लिए इवन एट द फर्स्ट डिफॉल्ट यू कैन इन्वोक द प्रोविजंस. कुछ लोग प्रोविजन को मिसयूज करके कोई एक ऑपरेशन लेटर लगा लेता है एप्लीकेशन, और उसको, मैं ये नहीं कहना चाहती ब्लैकमेलिंग करता है, पर नेचुरली वो उसके कारण एक बहुत बड़ी कंपनी एकदम लिक्विडेशन में आ जाती है, इंसॉल्वेंसी आ जाती है, जिससे उसकी वैल्यू घट जाती है. सो जब इंसॉल्वेंसी प्रोसेस स्टार्ट होगा, सर्टेनली उसके शेयर्स डाउन हो जाते हैं, या वो उसकी वैल्यू भी कम हो जाती है. क्या हम जान सकते हैं पहले से कि हर साल यदि बॉडी चेकअप हो कॉर्पोरेट का, उसकी वैल्यू क्या है? कैन वी हैव प्रोसेस or provision that every year fair value and liquidation value needs to be determined and should be on the paper, so that at the time when the insolvency process starts, one comes to know that prior to insolvency process this was the fair value and the liquidation value of this corporate. यदि हर साल हम करेंगे शायद बेहतर होगा. वैल्यूएशन प्रोफेशनल्स करते हैं इसको, वहां में भी हम लोगों ने वैल्यूएशन प्रोफेशनल या इंटरनेशनल पैरामीटर्स से करेंगे, और चूंकि वो प्रोफेशनल की कैटेगरी में आ गया, तो सर्टेनली वी नो दैट कि अब जो वैल्यूएशन वैल्यू से पहले करते थे जब रेगुलेटेड नहीं थे, तब वो कहना कुछ नहीं चाहूंगी, पर हाँ कुछ वैल्यूएशन ऊपर नीचे होते थे जिससे कि एनपीए में फर्क पड़ा है, और या कुछ मिस्चीवियस एक्टिविटीज भी हुई है जिससे कारण ज्यादा लोन दे देना, नहीं चुकाना, मतलब पीपल यूज्ड टू मैनिपुलेट एंड मैनेज, हैविंग एडवर्स इफेक्ट ऑन द इकोनॉमी ऑफ द कंट्री एज अ होल. कई वैल्यूअर्स ऐसे ही करते रहेंगे तो नेचुरली वैसा हो जाएगा. सो वैल्यूअर्स को भी रेगुलेट किया, सो दैट दे आर आल्सो नाउ अकाउंटेबल एंड रिस्पांसिबल. कैसे ऐसा नहीं कर सकते आप, आईपी तो है, कोड ऑफ कंडक्ट है, बट उनको भी किया गया है कि ताकि आप ऐसा नहीं करें. एंड आई होप दैट कि रजिस्टर्ड वैल्यूअर्स आर एंगेज्ड बाय एवरी इंस्टीट्यूशन एंड एंटिटीज. अब वो अनरजिस्टर्ड वैल्यूअर का काम नहीं रहना चाहिए. जैसे हम कहते हैं आधार कार्ड जिसके पास है वो अकाउंट खोल सकता है, वो ये कर सकता है, उसी प्रकार से अनरजिस्टर्ड वैल्यूअर कोई भी वैल्यूएशन काम न करें. सभी कानूनों में एक जनरल आ जाना चाहिए कि रजिस्टर्ड वैल्यूअर से काम कराएंगे. नाउ रजिस्टर्ड हो गए, बट व्हाट अबाउट द कैपेसिटी ऑफ द वैल्यूअर्स, व्हाट अबाउट द कैपेसिटी ऑफ द आईपीस? दैट इज अ बिग प्रॉब्लम. आर वी प्रिपेयर्ड टू हैंडल कॉर्पोरेट इंसॉल्वेंसी? अब कॉर्पोरेट इंसॉल्वेंसी आने वाला है, but prior to that I request corporate professional organization that they should conduct training program or capacity program for the corporate insolvency also. क्योंकि जब भी कोई केस आएगा वो ट्रायल और एरर ही होता है हमारे लिए, and we learn from the trial and then we amend things or we mend our ways. So prior to that, if we come to know that after corporate insolvency these problems will come, will be faced by the professionals, what should be the preparation they should keep? घर में हम जब रखते हैं, क्रोसिन रखते हैं, डिटॉल रखते हैं, या कुछ और भी क्रीम रखते हैं कि भाई कुछ इमरजेंसी आएगा तो ये हम इससे फेस कर लेंगे, फिर डॉक्टर के पास बाद में चलेंगे. Similarly, every profession needs to keep that kind of preparation. यदि इंश्योरेंस प्रोफेशनल है, they should have a panel of managers, specialized managers, maybe steel, textile, service sector और other field. उसकी एक लिस्ट रखें आराम से, वैल्यूअर्स की लिस्ट लिखे जो अच्छा वैल्यूएशन करते हैं. और आज मैं अपने मेंबर की तरह बुलाया है, पर मैं कुछ अपना पर्सनल भी कहना चाहती हूँ. जब हम कोई डॉक्टर को एंगेज करते हैं तो हमारा परिचित डॉक्टर को हम एंगेज करते हैं, कहते हैं कि इसको एंगेज कर लो, अच्छा है, ठीक से देख लेगा, प्रायोरिटी पे देख लेगा. बट इन टर्म्स ऑफ कॉर्पोरेट लॉ, वो फॉल करता है रिलेटेड पार्टी। एंड रिलेटेड पार्टी ट्रांजेक्शन, आई थिंक दैट्स द बिगेस्ट चैलेंज टुडे, क्योंकि आप करवाना चाहते हैं अपनी व्यक्ति से जो बहुत अच्छा है, जिसको आप जानते हैं, जो वेरीफाइड भी है, जो गलत काम नहीं करेगा, बट और हैंड्स आर टाइड कि वो रिलेटेड पार्टी में आ जाएगा। सो रिलेटेड पार्टी ट्रांजेक्शन को उसमें मंथन मनन चिंतन करने की जरूरत है कि कहाँ पर लक्ष्मण रेखा खींची जाए, कहाँ पे लक्ष्मण रेखा खींची जाए। अभी भी वो हर छोटी चीज में मैं कभी सोचती हूँ कि जब मैं कुछ काम करती हूँ तो अपने वालों को देती हूँ, मैं चाहे वो ज्यादा पैसा ले, पर मैं जानती हूँ वेरीफाइड है, ट्रस्टवर्दी है, काम ठीक करके आएगा, और नए व्यक्ति को दूंगी तो कैसे पता लगेगा। तो ये बात सही है, अपने वालों को देते हैं तो हाँ, ये अपने वालों को दिया तो अपने वालों को प्रॉफिट दिया, यही तो बात आती है रिलेटेड पार्टी में। शायद इस पे मनन चिंतन करने की आवश्यकता है। एवरी ईयर देयर हैज टू बी अ फेयर वैल्यू और लिक्विडेशन वैल्यू, उसका एक चेकअप हो, ताकि ये इंश्योरेंस प्रोसेस में एग्जैक्टली पहले का क्या फिगर्स थे वो पता लग जाए। समटाइम्स प्रॉपर्टीज आर अटैच्ड, I mean properties are attached, then how to assess, how to submit asset memorandum for liquidation or to prepare information memorandum for during sale process. So ये कुछ प्रॉब्लम्स आती है, उसको भी डील करना होगा कि क्या ईडी जब करती है सिंबॉलिक अटैचमेंट करेगी, अदरवाइज इट विल कंटिन्यू। और तीसरी एक बड़ी बात है, रिसेंटली वी हैव नोटिस्ड few professionals IPC have been arrested. Whether a professional is a public servant or not, I think this requires a big debate. यदि प्रोफेशनल को हम प्रोटेक्शन नहीं देंगे तो फिर कोई भी एजेंसी गवर्नमेंट की या कोई भी व्यक्ति विंडिकेटिव एक्शन लेके उनको परेशान कर सकता है। सो आई थिंक यहाँ पर भी देखना होगा कि whether he is a public servant। चौथा, जब आप प्रोफेशनल काम करते हैं और बहुत बड़े ऑपरेशंस होते हैं कंपनीज के, तो वहां पे हम देखते हैं कि एक व्यक्ति काम नहीं कर सकता है। डॉक्टर दवा अकेला लिख सकता है, पर ऑपरेशन करना है तो उसको हॉस्पिटल चाहिए, ओटीबी चाहिए। सो सिमिलरली आईपी आल्सो रिक्वायर्स अ बिग लेवल ऑफ सपोर्ट सर्विसेज। उसको क्लेम वेरीफाई करना है, कलेक्शन करना है, और उसको फिर बाद में तैयार करना है, लोगों को जॉब भी देना है, मतलब देयर आर नंबर ऑफ प्रोसेसेस I think undertaken by him under the umbrella process of resolution process। वहां पे उसको सपोर्ट सर्विसेज चाहिए, वो सपोर्ट सर्विसेज जो बाहर से लेता है, whether that support services can be termed as a professional or not, they are providing, they are not professional but they are providing professional services, and professional services means any service which is provided in a professional way, in a very organized way। पहले से कॉन्ट्रैक्ट होगा, उसका पैसा तय होगा, और आप कितना काम करेंगे, मतलब सब कुछ पहले ही बार्गेन हो जाएगा, ऐसा ऐसा करना है आपको, इससे बाहर नहीं जाएंगे, ठीक है। तो एक प्रोफेशनली वे में सर्विस प्रोवाइड करना, पर whether they will be termed as a professional or not, whether their engagement would fall under the professional, whether their engagement requires COC approval every time, though it requires COC approval because a huge amount of fee is involved। but ये एक ऐसा एरिया है जहां पर I think action have been taken by the IBBI also, that कि वो प्रोफेशनल नहीं है, बिकॉज आज के इस ग्लोबलाइज्ड वर्ल्ड में जहां पे सब कुछ इंस्टीट्यूशनलाइज्ड है, वहां पे एक सिंगल व्यक्ति प्रोफेशनल के रूप में काम करेगा और बाकी दूसरों को हम प्रोफेशनल रिकॉग्नाइज नहीं करें, आई थिंक दैट इज क्रिएटिंग सम chaos इन द सिस्टम। लोग काम कर रहे हैं, स्टेट बैंक ऑफ इंडिया प्रोफेशनल एजेंसीज को लेती है अपने पैनल पर, but there we don't object, but when a single individual insolvency professional वो अपना कुछ करता है, करने का उद्यम उठाता है, तो उसको कितना हद तक रोकना चाहिए। आई थिंक यहाँ पर कहाँ रोकना है, कहाँ नहीं रोकना है, उसके लिए एक बहुत बड़ा मनन चिंतन चाहिए, ताकि सीमलेस तरीके से लोगों को सर्टिनिटी रहे। उन्हें एंगेज कर लिया, उन्होंने पैसा दे दिया, बाद में पता लगता है कि गलत हो गया है और आपको डिसिप्लिनरी एक्शन आ रहा है या कोर्ट में एक्शन आ रहा है, तो उससे प्रोफेशनल्स का मॉरल डाउन होता है और प्रोसेस में तो अफेक्ट पड़ता ही एडवर्स। जिस काम के लिए टाइम बॉन्ड लगा है उससे नंबर ऑफ लिटिगेशन जनरेट हो जाते हैं एक साथ। तो मैं अर्ज करती हूँ कॉर्पोरेट प्रोफेशनल्स को कि जो इश्यूज आ रहे हैं ये, इन पर ज्यादा मनन चिंतन करके मे बी काइंड ऑफ कुछ रिकमेंडेशन या आपके जो भी सजेशंस हैं यू कैन फॉरवर्ड, सो दैट जो ये प्रॉब्लम काउंट पे आ रही है उनको सॉल्व किया जा सके। और दूसरा है वैल्यूअर्स का, वैल्यूअर्स के लिए भी कोड ऑफ कंडक्ट है, सीओसी के लिए कोड ऑफ कंडक्ट है, और कोड ऑफ कंडक्ट में प्रॉब्लम आती है हु इज रेगुलेटिंग दैम। but COC, kisko regulated, COC members regulated by the Reserve Bank of India. So some kind of umbrella regulator is required now. एक umbrella regulator required है, और umbrella regulator के नीचे उनके अपने staff का भी selection होना चाहिए, so that they understand the regulatory mechanism and can work well. जैसे हमारे central staffing scheme है, ऐसे regulatory staffing scheme होना चाहिए. और help desk transparent scheme maintain करने के लिए जैसे income tax में advance ruling authority, ऐसे ही कुछ help desk nature का कुछ start to begin with हो सके तो हो जाएगा सरकार के द्वारा कहीं, तो शायद मुझे लगता है प्रोफेशनल्स को ज्यादा फैसिलिटी मिलेगी, क्योंकि नई नई प्रॉब्लम्स है, कभी कभी interpretation is the domain of judiciary, I know that, but for every small interpretation, if we approach this NCLT, it's expensive, time consuming, and halts the process. So with these words, I congratulate and I wish all the best to the corporate professionals for organizing this webinar, and I hope that they will discuss whatever issues I have pointed out, but maybe other issues may come across which I'm not aware of it, but certainly I would be happy if these issues get some concrete suggestions, so that there is a harmony and coordination among the professionals and other professionals or other stakeholders also. Thank you very much.
Thank you very much, madam. Thank you. We assure you, because all the program which we are organizing, whatever questions are coming from public side, we are sending to regulator, and we are requesting them. This is the issues which corporate world is facing or professionals are facing, and we are happy to inform you, madam, because of our efforts of webinar, we have tried to give the proper feedback to regulator. Recently, SEBI came out with PIT guideline and FAQ, which came from this program's discussion. So we are shortly organizing the cross-border insolvency program, and whatever suggestion today we will receive, we will give it to you. That is, after the Amit Pradhan sir, we have some questions from the public which they are asking from the regulator. I'll request you to please share. I'm sending you the question which I have received, so you can in the meantime you can glance through, madam. Okay, so now the entire the resolution plan and the entire insolvency law, it has so many pillars. So one of the most important pillars is resolution professional, and Amit Pradhan sir is managing the code of conduct and their guidelines and other thing. So I will request Amit sir that what is your take on the entire insolvency, and especially relating to the insolvency professional. Over to you, Amit sir.
Thank you, Vaman Vijayji. First of all, namaskar to everybody on the panel, and also who have joined this webinar online. And before I start on the topic, Pavanji, I would like to congratulate for releasing this book. I think this takes me back to my school days, maybe college days, when LLB we used to, in the Companies Act, we used to see Ramayya. It was iconic and decorative piece of books also. So I'm sure you have raised to that standard in respect of IBC, and this book was really needed. I'm telling you, because this law, as we all know, is just 5 years old, and jurisprudence is emerging day-to-day basis. So you have just shown us some presentation through slides that on each and every section you have tried to insert some jurisprudence, and that was really needed. And only request is that if any changes in that jurisprudence, that also needs to be updated. And if possible, try to come out with some e-book also on this, because that will reach to the people at large also, and easy to access, and there will be some searchable options also. So if you can convert this book into the e-book, that will be a great thing. So as you just said, that my profile in IBBI includes regulation of service providers, and I will try to focus on my talk on service providers, which are individuals and institutionals, and also touch upon few processes and missing areas just a little bit. just to suggest what is the road ahead for all these areas. So, as you know, that India has taken big step in resolving corporate insolvency since the enactment of the Insolvency Code in 2016, but challenges to speedy resolution persist. So the IBC streamlined the process by releasing a number of old regulations and creating incentives for all stakeholders for speedy resolution. It also created disincentivizes for willful defaulters. As a result, recovery rates, time taken for resolution, and the number of cases resolved have improved a lot since 2016. Nonetheless, the resolution process has taken longer than the timelines prescribed under the code. That may be due to many reasons. That may include also excessive litigation, challenges being made to the insolvency process, or even sometime to the law, rules or the regulations framed by central government or the IBBI. A number of amendments have also been brought in the IBC, which should help, but there is still room for further improvement. And the road ahead, I will be discussing in three sections. One will be like building institutions. The other may be process improvements, and there are certain third one is certain missing areas which the code may need some amendments, or maybe the some regulation needs to be framed for that purpose. As regards building institution, that matter and that makes a difference. So, see, given their role in insolvency process, the institutions of insolvency and bankruptcy needs to be strengthened further. So one of the most important institution in IBC is the Insolvency Professional. So when you talk about IBC, I think that is the first name come to your mind. Insolvency Professional. So the insolvency proceedings require high-end, sophisticated professional services. The code casts, unlike many advanced jurisdictions, a rigorous responsibilities on an IP to run the affairs of the firm in distress as a going concern, to protect and preserve the value of its property. Also to comply with all applicable laws on its behalf and conduct the entire process of resolution with fairness and equity, retrieve value lost through avoidance transactions, and so on. So the promising professionals from discipline of law, management, accountancy, etc. So with 10 years experience, or maybe as a managerial experience with 15 years experience, they have joined the insolvency profession after undergoing a pre-registration training and passing the limited insolvency examination. And the result is that they have performed admirably well. And we cannot doubt their performance at all. To take the insolvency profession to the next level, IBBI has conceived a 2-year graduate insolvency program for young and bright minds, having a professional qualification or a degree in a relevant discipline, but with no experience. That is important. So this GIP program aims to groom tailor-made IPs and inculcate all that an IP needs, including the soft skills such as people management, entrepreneurship, emotional quotient, and deep-rooted ethics and integrity. On completion of this GIP program, one would be eligible for registration as an insolvency professional without the need for the 10 years or 15 years of experience. So GIP is the first of its kind in the world, and it's an endeavor to create an insolvency as a discipline of knowledge. The first batch of this GIP, 1921, which is the course run by IICA, Institute of Corporate Affairs, has successfully been completed. And IBBI has also granted registration 15 such pass outs, and they are already working in the IP profession. IBBI has also granted approval to one more institute, which is NLU Bhopal, to conduct GIP classes, and these classes are likely to commence this year, July onwards. So it will be the initiative of IBBI to spread this GIP GIP as a career opportunity for young professionals. And also, we will induct more and more universities which can run this course for the betterment of this profession. So another profession which is very important in the insolvency process is the valuation profession. One of the key objectives of the code is maximization of the value of assets of the persons in distress. One needs transparent and credible determination of the value of the assets, facilitate comparison and informed decision. The valuation serves as reference for evaluation of choices, including liquidation, and selection of choices that decide the fate of the firm undergoing a resolution process. If valuation is not right, a rival firm could an unviable one could be rehabilitated, which could be an unfortunate for the entire system of the economy. So the decision arising from use of inappropriate values in addition to causing unfair gains or loss of parties has the potential to distort market and misallocate resources which may impinge upon economic growth in the market economy. So, this regarding this valuation provision, an interim framework has been put in place under the Companies Act, and also rules have been framed under the Companies Act, and under that rules, IBBI is the authority to regulate this profession. Further, in furtherance of this profession, to make it more viable or more regulated, there was a committee of experts which was constituted by the government. And the committee has recommended enactment of an exclusive statute provide for establishment of National Institute of Valuers, protect the interest of users of valuation services in India, and also to promote and development of and to regulate the valuation profession and market for valuation services. This should ensure that valuers enjoy an enviable reputation of the stakeholder while being accountable for their services. Here also the endeavor is noble and aims to create the subject of the valuation as an independent discipline of law. So we are very hopeful that this law will see the light of the day, and maybe after that this valuation profession will be further strengthened and well regulated. Another a service provider in the area of this insolvency is information utility. So the resolution process is very information intensive. Value depends on availability of quality of information with the stakeholder. The code provides for a competitive industry of interoperable IUs to store financial information that helps to establish defaults, verify claims, constitute ICOC based on claims, generate information memo expeditiously, and thereby facilitates completion of insolvency process in a time-bound manner. To ensure that IUs capture the information necessary for the insolvency resolution process and the bankruptcy process, the code also makes data submission mandatory for financial creditors and imposes an obligation on IUs to accept such data. To ensure accuracy and preclude disputes, code mandates that such records be co-verified with all the concerned parties. When IU has come up and is gathering a critical mass of information for use by the concerned stakeholders, this is also first of its kind in the world of to address information asymmetry. Insolvency is paid, but it will get a push if creditors extending credit above a threshold. Any person are also mandated to submit financial information when IU, and the borrowers taking a credit above a threshold from any person are mandated to authenticate the information. So the background of this shortcoming is at present the code provides doesn't provide an obligation on the part of the debtor to authenticate the information of the credit which is given by a creditor. So that way, sometimes what happens, information is not authenticated by the debtor. So in the courts, terminals, it may take more time to initiate insolvency process. I believe government is considering this amendment to make authentication of the loan on the part of debtor as a mandatory. And that will happen soon. So another institution which is involved with a committee of creditors. The COC, which comprises financial creditors, has a responsibility to decide the fate of the firms in distress, whether to rescue or liquidate. Decisions of the COC are not generally open to any analysis, evaluation, or judicial review by the. So, just to say in short, I would say that given such decisions to which are taken by the COC, they are very that depends that decide the fate of the resolution. So all rounds efforts are being made to strengthen the institution of the COC to meet its responsibilities, and the possibility of the code of conduct for COC is not very far away. Another institution which is involved here is adjudicating authority, without which no resolution can happen without their approval. So this NCLT, which is created under the Companies Act, discharge responsibility under the Act, and that also is interested with responsibilities as an adjudicating authority under the IBC. So bench capacity needs to increase commensurate with the responsibilities under both the enactment. Capacity of a member of to dispose of matters can be enhanced by provisions of quality and research support. The authority should have strong administrative support and scrutinize the applications, filings for accuracy, completeness, and compliance with the requirements, and manages information technology to manage the cases. Scheduling that releases members to focus on adjudication. So simultaneously, effort needs to also be made to resolve stress by mediation, and also conciliation, or through process such as pre-pack, which is already in place, which will reduce the burden on the adjudicating authority. So certain process-related improvements also I would like to touch upon, with maybe like as a road ahead, we will be seeing in the time to come. So the as regards responsive regulations, IBBI as the regulator, IBBI has no parallel elsewhere in the world. It makes regulation amongst others, and regulation for corporate and individual insolvency, liquidation, and bankruptcy process. A responsive regulator designs and modifies regulations proactively with changing needs of the market without unduly restricting freedom of participants and with the least unintended consequences. And to ensure that IBBI has standardized the regulations, making process to ensure that regulations are effective as well as responsive and not effective. We have a mechanism which is called as IBBI mechanism for issuing regulations, which we came out in the year 2018, which governs the process of making regulations, which includes cost-benefit analysis and also the wide consultation amongst the public. It is imparting training to its employees also on regulatory impact assessment to ensure that regulations factor ground reality, secure ownership regulations, and makes regulation robust, precise, relevant to the time and purpose. We are conscious about our role. We are working on it, and we are coming out about with some amendments also on need-to-need basis. Another issue which is the resolvability. The code has shifted this focus of creditors from the possibility of the recovery to the possibility of resolution in case of a default. The market now prefers to deal with a company which is resolvable. A resolvable company obtains a competitive advantage over a non-resolvable company through reduced cost of the debt. So idea is like companies should be ready with this plan of if in the eventuality of any resolution, which on account of a debt, if some company has to face. In a sense, it would be having a sort of living will for the benefit of the firm as well as the society. Another issue is concerning resolution is market for distressed assets. So India is the fastest growing $1 trillion economy and the 5th largest in the world. The average growth rate over the last 3 decades has been about 7%. All vital stats such as index for competitive, index for innovation, has been improving over the years. Given the size of the economy and its growth potential, there will be a continuous flow of distressed assets. They would need to be resolved, not necessarily through SCR. It would be bought even in early days of distress. Regulation could facilitate the development of a secondary market for corporate loans. Several platforms provide the details of such stress asset. In short, we call it PDS. And already two agencies are providing this distress assets market platform services. One is NES and the other one is LLC. Another issue which may facilitate this resolution is the automation of the contracts. It often takes time and effort for an IU to receive the information from one of the parties to a loan agreement and then seek verification from other parties before the information is used. Automation of loan contracts, standardization of the loan agreements, demat of loan agreements, and their online execution will make the process of contracting very efficient and obviate the need for explicit authentication. So this will facilitate seamless insolvency proceedings like the automation has regulated securities market. It's a kind of dematting shares, either dematting of the contract. So another way we can look ahead is the best practices. Best practices is a kind of study or the analysis which is being made by IBBI and also its service providers such as IPAs, and that studies we have been working with developing, and that can give a lot of solution to the problems. So briefly, I will also touch upon the missing elements, which you may call it as a project in pipeline kind of thing. So the third side is implementation of the missing element. So individual insolvency is also is also a provision which is yet to be operationalized. Although this personal guarantor provision has been notified, and now it is effective. Another thing is fresh start process that also needs to be operationalized. As regards fresh start, already this one committee, INC, has recommended redesigning the fresh start process to make it accessible, simple, quicker, and cost effective. And three major changes it has recommended, like shifting from quasi-judicial process to an administrative one, whereby dedicated debt relief officer oversees the process and issue debt relief orders at low cost. Shift from IPs to the less costly insolvency advisor to assist and guide eligible debtors, and also to implementation of the fresh start process on an online platform accessible from anywhere. This will require change in the code along with development of a dedicated administrative mechanism, a cadre of insolvency advisors and technology. And another issue is cross-border insolvency, which is also which is also needed amendment in the act, and we are very hopeful that this can also see a day of the light very soon, in the recent future. Relating to this also is a group insolvency. There is an increasing preference to organize business in a group of companies to harness synergies among them. May be useful to deal with the insolvency of a group of companies together. Certain circumstances to preserve synergies among the group or value maximization. So there is a need to provide for framework to enable synchronization of insolvency proceeding of group companies, where it promotes the objective of value maximization. With this, I stop here and thank you all for this opportunity. And again, I congratulate Pavanji for very exhaustive book on the bankruptcy. Thank you.
Thank you, Amitji. Your experience in SEBI and then CCI and then now IBC will pave the way and give the new dimension. That is the beauty of the Indian government system, that they and send different officers to different places so they can bring the culture on this. Sir, now the time is for a few questions from the regulator. Madam, can I just ask you one important question? What are the key issues faced by the corporate due to pandemic and after effects? I think Madam is joining. Amitji, can you give answer this? What are the key issues faced by the corporate due to pandemic and after effects?
It was the issues were only debt related, but government was proactively they have suspended it also for a certain period. This insolvency and this working insolvency, and definitely that's because of this business disruption and all that has suffered a lot.
Okay, sir, you know the first pillar of IBC is IP. How to strengthen this, and whether the will you suggest any criteria to fix fees or professional involved in CIRP process? What is your suggestion on this?
On the fees, is a one of the big issue for the IPs. Generally, this IBBI doesn't interfere in the fee fixation, because that is a job done by the COC, and with the approval of COC only, and IP is supposed to charge the fees. Recently, a lot of jurisprudence has come, and they have discouraged certain undesirable practices as regard the fees charged by IP. So one of the recent judgment is fee success fee, which was asked by the IP, and that has been that was asked at a very later stage. The NCLAT and the NCLT both came out very heavily on that, saying that an afterthought and kind of the thing, it is just to will put in a cost to the CRP, and the success fee has not been prescribed anywhere. So I think that code of conduct also of IP under the IP regulation generally deals with this, and we only say that it needs to be reasonable, commensurate with the working of the IP on a given assignment.
Sir, the liquidation is the last resort. That is the aim of IBC also. Madam, can you join, please? Can you join?
Okay, fine.
So liquidation should be the last resort. But in the past, it has seen that people are following, especially the IP, that liquidation is more remunerative than the running of the company. So you have any plan to control this particular misuse of doing this, because the insolvency law is not for liquidation, it is for the running of the business. So on the professional side, can you suggest something that what actions IBC is planning to do?
मैम आपको बताएंगे
मैं आपको क्वेश्चन रिफ्रेज करता हूं मैडम. Liquidation should be the last resort, but however the role and functioning of resolution professional COC and the process of value is sometimes responsible for liquidation, especially where the creditor have vested a specific interest. What message would you want to give in the furtherance to object of this code? Liquidation should be the last resort.
Yeah, a very good question. Thank you. I think first we should understand what is this liquidation. It is an extension of the CRP process. It is not a liquidation as such initiative afresh. When CRP fails, then this is another step. So actually we call it as liquidation, but it is another step which is an extension of the CRP process. And when it is when we have added the provision in 2018 regarding sale as a going concern, sale as a going concern. I think recently I come across one CD where sale as a going concern and it was in profit, because we have a condition that CRP, if it is not completed within 180 days or 330 days a maximum, or there is a violation in the implementation plan, as per section 33, there are a number of conditions, but one of them is that, or the COC decides to liquidate at any point of time. But for the purpose of liquidation under this code, first you have to initiate CRP only. Then there will be liquidation. So the liquidation is an extension of CRP. That means last, it's not last resort. Again, in the liquidation process, if it fails, time is over, fine. Then again in the liquidation process, you have to go for a beneficial liquidation. It's not simple liquidation, parcel sale कर दिया सब piece में नहीं, उसको आप going concern बना के रखिए, so that you get good prospective buyers also. And sale as a going concern बनाएंगे, उसके कई फायदे हैं, सबको मालूम है. टुकड़ों में कंपनी बिक जाएगी, नथिंग, वो शमशान घाट की तरह बन जाएगा, वहां कुछ नहीं मिलेगा, सिर्फ हड्डियां मिलेंगी. इसके बजाय सेल इज एवरी आरपी शुड ट्राई दैट. यदि फेलियर हो गया है, दैट ही शुड नॉट, उसको अपना होप लूज नहीं करना चाहिए. उसको जो लिक्विडेशन में आ गया है वो गोइंग कंसर्न बना के मेंटेन करके रखे, सो दैट यू विल गेट ए गुड बायर. और उसके बाद सेल इज गोइंग कंसर्न होगा, अच्छे बायर मिलेंगे, सो कंपनी विल बी अलाइव, रनिंग होगा, एम्प्लॉयमेंट ऑफ द एम्प्लॉयज विल बी वहीं बना रहेगा, उससे नुकसान नहीं होगा. और वो भी एक रिवाइवल ही है. व्हेन यू सेल एज अ गोइंग कंसर्न, इट्स काइंड ऑफ अनदर रिवाइवल, अनदर रिजोल्यूशन प्रोसेस. हम उसे लिक्विडेशन कह रहे हैं, ठीक है, नाम दे दिया, बट इट्स अ काइंड ऑफ द लिक्विडेशन, इट्स अ एक्सटेंशन ऑफ द सीआरपी प्रोसेस. सो उसमें भी लिक्विडेशन के प्रोसेस में भी उतने ही एफर्ट्स आईपी और आरपी बनता है लिक्विडेटर, वो भी नहीं है, बिकॉज ही नोज द होल हिस्ट्री. सो यदि कुछ रह गया है, कुछ कमी बसी रह गई है, हाँ ये बात है कि दैट प्रोसेस certainly requires further amendment, क्योंकि it is extension of it. और यदि शेयर प्रोसेस और लिक्विडेशन ज्यादा गैप नहीं है, so maybe that valuation का जो रिजल्ट आया है, वैल्यूएशन जो दिया है, फाइंडिंग, it can be adopted because there is not much of the gap. So उस प्रोसेस को भी कट शॉर्ट करके और सिंप्लीफाई कर सकते हैं, so that प्रोफेशनल्स भी एक क्रेडिट लेते हैं कि मैंने गोइंग कंसर्न रखा है. गोइंग कंसर्न रखना भी एक बहुत बड़ा चैलेंज है हर एक के सामने. और दूसरी बात यह है कि उसमें यदि अपफ्रंट मनी डालना, मतलब इस लिक्विडेशन प्रोसेस को भी थोड़ा सा और स्ट्रीमलाइन करें और अच्छा बनाएं. कुछ और प्रोविजन जो मार्केट कहता है कि ये कैसे अच्छा, लिक्विडेशन को जैसे हम कहते हैं स्टीमा नहीं होनी चाहिए, इंसॉल्वेंसी का, ऐसे लिक्विडेशन में स्टीमा ना माने, वो दूसरे हाथों में चले गए हैं. पर जहां पर बॉटलनेक्स आ रहे हैं लिक्विडेशन में दूसरे हाथों में देने के लिए भी, उसको इम्प्रूव करें. एक दिन ऐसा आए कि प्रोफेशनल्स कंपनी को इतना बढ़िया चलाए कि वो कॉर्पोरेट डेटर कहने लगे कि अच्छा इसको इंसॉल्वेंसी डाल देते हैं, जरा काम अच्छा हो जाएगा, इसको इंसॉल्वेंसी प्रोसेस में डाल देते हैं, ये कंपनी और दौड़ेगी बुलेट ट्रेन की तरह. कुछ प्रोफेशनल्स अपना कंट्रीब्यूशन इस तरह करें कि लोग इंसॉल्वेंसी वाली कंपनी को खरीदना पसंद करें, इंसॉल्वेंसी वाली कंपनी को खरीदना पसंद करें. कुछ इस तरह से प्रोफेशनल्स अपना क्रेडिट, अपना कंट्रीब्यूशन दें, और नेशनल सर्विस होगी.
But madam, the problem is there is a contradiction in the law when we, like just now you have said RPT issue, related party, okay, and there are some restriction also. So one way you want to promote individual IP, but in practical, when you want to run a company, the professional of CS, CS and advocate and CWA, they are expert in one area, they are not a business expert. They require the help of others. So the point is, this institution of creating this type of image and work, we require lots of changes and lots of hurdles which are there should be removed from the system. Today, what is happening? The entire work is going to the big law firm and big four. The object of IBC was that you want to create individual people expert in various law. So I think that is missing. If you see the analysis, I have done the analysis. Majority work of big companies is going to the few hands, and the donkey's work is going to the all other people in their things, which are companies which are only is few things. So it is creating a disbalance. So I this is my just suggestion that IBC must look into this, that how this can spread evenly, and where more culture, more innovation can come.
You're fine, but I also feel that when you IP has to perform dual role. One is managing the affairs, other is conducting the whole process. So he himself cannot do this function properly, efficiently, and he is not also well versed in managing. He is not a well versed advocate. Is not well versed in managing the company. Never they have managed. कभी मैनेज नहीं किया, उनको मिल गया कंपनी मैनेज करना. सो एक कमिटी ऑफ प्रोफेशनल्स हम कह सकते हैं, जिसमें एक आईपी भी हो, एक मैनेजमेंट भी हो, एक सीए भी हो. यदि इस तरह का अरेंजमेंट आता है रिजोल्यूशन के लिए, दो बातों में मैं कहना चाहती हूँ कि यहाँ पर यदि कमिटी ऑफ प्रोफेशनल्स को अपॉइंट किया जाता है तो शायद बेहतर तरीके से मैनेजमेंट होगा, अच्छा होगा। दूसरा है कि सीओसी वाले ग्रुप में भी, या मैं आपके प्रश्न के अलग बोल रही हूँ, सीओसी में भी यदि हम रिलेटेड पार्टी वाला कहते हैं कि सीओसी मेंबर कैन नॉट गिव द प्लान, और प्लान देते हैं तो रिलेटेड पार्टी हो जाता है, बहुत कुछ बातें होती है। तो सीओसी मेंबर में जहाँ पे क्रेडिटर भी प्लान देता है, वहां पे 2 इंडिपेंडेंट डायरेक्टर्स की नियुक्ति होना चाहिए, ताकि वो वोटिंग शेयर पैटर्न, उसकी जो ब्लॉकेज, जो एक स्टेलमेंट आ जाता है कि सब अब वोटिंग कैसे होगी, सिस्टम कैसे आएगा। तो जैसे इंडिपेंडेंट है हमारे, उसी प्रकार से यहाँ पे आईबीबी तो ही इज आल्सो एक्सरसाइजिंग पावर्स ऑफ बोर्ड ऑफ डायरेक्टर्स, सो व्हाई शुड नॉट बी हियर आल्सो इंडिपेंडेंट डायरेक्टर्स। तो यदि वो इस तरह का सिचुएशन आता है तो शायद चीजें मतलब सिंप्लीफाई हो जाएंगी और कोई ऐसा रुकावट नहीं आएगी, जैसे कि सीओसी अप्रूवल नहीं दे रही है, क्योंकि अप्रूवल नहीं दे रही है, जैसे रनिंग कंपनी चली गई लिक्विडेशन में, तो अप्रूवल न रुके सीओसी का। प्रोफेशनल, यदि कमिटी ऑफ प्रोफेशनल्स है, तो जो आप बात कह रहे हैं कि यदि ऐसा होगा तो मे बी जो बिग 4 में जा रहा है, यदि हर केस में कमिटी ऑफ प्रोफेशनल बन जाए कि भाई एक मैनेजमेंट वाला व्यक्ति रहेगा, एक आईपी रहेगा, या एक और कोई हो सकता है, जैसे भी सरकार सोचे या सारे आप लोग प्रोफेशनल सोचे और सजेशन दें, तो फिर ये बिग 4 में जो कॉन्सेंट्रेशन हो रहा है चीजों का, वो शायद कम हो जाएगा। क्योंकि अभी भी हम जब जाते हैं किसी वकील को करने के लिए, डॉक्टर करने, तो देखते हैं ऑफिस के साथ डेकोरम कैसा, कितने लोग काम कर रहे हैं, हाँ बहुत अच्छी प्रैक्टिस चल रही, बहुत लोग काम करते हैं। वो ये बिग 4 के साथ हो रहा है, जो अकेला बैठा है बिल्कुल बेस्ट माइंड, वो चुपचाप बैठा हुआ है। तो नेचुरली उसके साथ भी यदि एक कानून के द्वारा, रेगुलेशन के द्वारा यदि आ जाता है हमारा कि एक कमिटी ऑफ प्रोफेशनल्स होगी, डिफरेंट एरिया से रहेंगे वो लोग, तो शायद ये जो प्रॉब्लम बिग 4 की बता रहे हैं, वो मुझे ही मालूम बिग 4 की कॉन्सेंट्रेशन है। और दूसरी बात, बिग 4 सब मल्टीनेशनल्स हैं, क्यों नहीं इंडिया वाले भी ऐसे मिलकर अपना एक बनाए, आप तो चला ही रहे हैं, पर वैसे क्यों नहीं हम उनको कॉम्पीट करके उनसे बेहतर why can't we Indianize things? Why we depend on multinationals? We have to Indianize things, और उनके लेवल का ही कॉम्पिटिशन, उनके लेवल की सर्विस देनी पड़ेगी विद ऑल परफेक्शन इन अ वेरी वेल ऑर्गेनाइज्ड मैनर। तो शायद वो दिन दूर नहीं है कि जो आप समस्या बता रहे हैं वो खत्म हो सकती है। बट हाँ, आप सभी प्रोफेशनल्स को मिलके इस बात को चिंतन मनन करके, और आप ही को सुलझाना है कि बिग 4 को आउट नहीं करना है, बट एटलीस्ट बिग 4 के अलावा भी बाकी लोगों को बराबर से काम मिले। इफ यू वांट आई मीन एनी काइंड ऑफ प्रोविजन, आप सजेस्ट कर सकते हैं कि आप क्या चाहते हैं, किस तरह से होगा, बिकॉज ये मार्केट की प्रॉब्लम है, इसलिए मार्केट वाला इसका सॉल्यूशन बताएंगे कि ये सॉल्यूशन है। और नाउ आईबीबी कैन हेल्प थ्रू रेगुलेशंस, वी विल एग्जामिन इट, लुक इनटू इट, वी विल फर्स्ट वी हैव टू हैव योर सजेशंस and then we see that how we can lay down regulation in this regard.
Okay, Madan, all the experts which are there, I will request that everybody, where we have prepared a question for regulator, you can take up one question and ask. So then I will take public question and then other questions. So Madan, I will start with you. What is your question to regulator? Because you do practice in this area, you are facing this. So various questions are there which you can see. Can you just pose your question? Then I will ask Amit and Manoj and Karan. So be ready with your questions. Yeah.
If you allow me, can I give some suggestion instead of asking questions?
Yeah, you can give.
Thank you, Mr. Pawan. First of all, my compliments to you. And after listening to Dr. Mukilita Vijayvargiya and Mr. Amit Pradhan, I'm of the view that they are seized of all the issues which are there before the stakeholders. They are seized of all those issues. Only thing is that how to resolve, when to resolve, whether it is in the hand of IBBI or in the hands of Ministry of Corporate Affairs, how those issues are to be resolved. It's a matter of time, whether it is by change in the law or change in the regulations. Only those things are to be seen. Ma'am, I have some 5-7 suggestions, but I'm not there to ask any questions. Certainly, I cannot afford to ask questions to you. Suggestions are the research. Just now you discussed about this concept of going concern. Now, while keeping a company as a going concern, this IRP or RP is bound, or rather may have certain non-compliances of the provisions of the code. So if those non-compliances are because of keeping the company as a going concern, I think those non-compliances or technical contraventions should be ignored by the regulator. Number 2, Regarding this interim finance issue, ma'am, this issue is before everybody, every IRP and RP. Company is not having money, COC is not ready to give any money, and IRP or RP has to keep the company as a going concern. Now, where from he should get this money? This question has been before us for the last 5 years. All of us are seized of this issue, but still no solution has emerged where from this interim finance is going to come to keep the company as a going concern. Regarding fee issue, Dr. Amit Pradhan also raised this issue. This question was asked, particularly in case of those applications which are admitted under section 9 of the code and IRP is appointed from the panel. Now, there are no instructions or no advisory from the board to the adjudicating authority that what shall be the fee of this IRP. Adjudicating authority is also not fixing up any fee. Now, he is left at the mercy of the COC. COC is not ready to give any reasonable amount even. So in such cases where the appointment, at least where the appointment is from the panel, some advisory should be there that a minimum threshold fee shall be paid to the IRP or RP. And secondly, who shall pay this fee and at what point of time this fee shall be paid? Some sort of clarification is required on these three issues. Another, what I have observed, ma'am, during the last 3-4 years, particularly recently during last 1 year, that every claimant or creditor whose claim has not been admitted or whose claim has been rejected by the IRP or RP is not happy with him. Director of the CD is not happy with the IRP or RP. Unsuccessful resolution applicant is not happy with him. And unsuccessful auction purchaser and sometimes the successful auction purchaser is also not happy with IRP or RP. Now, the moment he is not happy, what does he do? He files a complaint against him, not an application before adjudicating authority, but a complaint against him before the adjudicating authority as well as before the board. And the moment a complaint is filed, he receives a summon that respond to this complaint within 7 days, 14 days, para was reply along with the documents and evidences. I think before sending the copy of such complaint, the locus of the complainant should be seen and whether the complaint has merits or not before sending this complaint to the IRP or RP to respond. Another, anonymous complaints, according to me, ma'am, should be avoided. No cognizance of anonymous complaints should be taken. One issue which is close to my heart and I have observed in a number of cases, ma'am, regarding replacement of resolution professional. Section 27. No reasons are given by the COC while replacing an RP. While the law says, section says if the COC is of the view that the resolution professional is required to be replaced. According to me, the section talks about that COC must form the opinion, but COC is never forming an opinion and COC is simply passing a resolution for replacement because COC is not happy with IRP or RP sometimes. They simply pass a resolution with 66% voting and IRP or RP, the RP is replaced. I think the reason should be recorded in writing. Otherwise, this RP is at the mercy of COC and this particular provision, section 27, hampers the independence of resolution professional. Because he's always under the pressure of COC that at any given point of time, they can replace me. Such a practice should be avoided. Another suggestion from my side, ma'am, that is SCN, whenever an SCN is issued, this SCN is issued on the basis of final report of the board. But this final report of the board is never shared with the IP. I think a particular report on the basis of which the show cause notice is flowing, that report has to be shared. We have to follow the principles of natural justice. Another issue, ma'am, which has risen recently in 3-4 cases I've seen, that AR is resigning in between. Or some of the stakeholders want to replace the authorized representative in particular cases of real estate projects. And there is no provision in law for replacement of AR or resignation of AR. Now, at this point of time, this entire CRP process is in limbo. Nothing is moving forward, and all the stakeholders are moving before the adjudicating authority. And adjudicating authority, which is already overburdened with a number of applications, is overburdened with these applications also. And no respite is there. I think some provision should be there regarding authorized representative replacement or resignation. Another question, ma'am, rather no, not question, suggestion only. This is regarding withdrawal. If the moment this application is admitted and the director of the CD is approaching the applicant and ready to settle immediately on the day 1 or day 2, and in a number of cases they are settling, they are filing a withdrawal application with the IRP. Now, in such cases, should IRP go ahead and publish the announcement in the newspaper inviting the claims? Because within a day, 48 hours, it has been settled. I think why the CD has settled? Because there is a question of tarnishing the image of the directors of the CD. He wants to save that image. Now, if in such a case, if an application has already been submitted, Form FA has been submitted to IRP, I think there should be provision, because IRP is duty bound to provide to comply with the law. In such cases, I think a provision should be there that IRP should not move ahead while publishing of the announcement in the newspaper till the time the verdict of the adjudicating authority comes. Though law says AA may accept this withdrawal application, but for all practical purposes, adjudicating authority is accepting this withdrawal application and the case stands withdrawn ultimately. So in such case, maybe to save this corporate debtor and its director from this loss of image building, such a provision should be there. I think there are other questions also. Pavanji is looking at me. I'm stopping here.
So, madam, there's no
I will answer briefly. As far as interim finance is concerned, I think market has to develop some kind of practice. Maybe whenever any company is incorporated or all the incorporated companies, we can have a cess for interim finance and every company can contribute. And there can be a pool of funds which is available to such companies also. We have a provision under the code that companies can contribute and they can, in case of insolvency, they can demand the contributed fund, no doubt. But if you have it's a kind of interim finance kind of welfare scheme for the corporates. So certainly every corporate, if it contributes, you can have a big pool of fund. The way we have legal aid, और legal aid वाले वकील को हम देते हैं ना कुछ पैसा अपील होने के लिए. IRP is also इस तरह इंटरिम फाइनेंस को भी आप कर सकते हैं और इस पे आप मनन चिंतन मार्केट करेगा, इंडस्ट्री सेक्टर करे तो शायद बेहतर होगा, क्योंकि सजेशन आने पर शायद उसको ज्यादा अच्छे से आर्टिकुलेट गवर्नमेंट कर पाएगी और बोर्ड भी कर पाएगा. सजेशन आप भिजवाइए. जहां तक फी का सवाल है, फी टू बी पेड, प्रोफेशनल्स आर नोवेयर इन द कंट्री. प्रोफेशनल फी क्या होगी? अब देख, छोटी कंपनी है, बड़ी लार्ज कंपनी, बिग ऑपरेशंस, बहुत सारी सब्सिडी है. हाउ विल यू फिक्स द फी? मिनिमम फी हो सकता है कि 2 लाख रुपए महीना रख दिया जाए किसी व्यक्ति के लिए, कह सकते हैं कि, पर कैसे? यदि कोई एसेट एक भी नहीं है, एक कमरे की कंपनी रजिस्टर्ड ऑफिस है जहाँ पे सिर्फ टेबल कुर्सी लगी हुई है, देन ऑल्सो इफ द असेट्स अटैच विद ईडी, तो आपको तो ईडी अटैच है तो आप कुछ कर ही नहीं सकते, तो आप क्या बनाएंगे उसका? तो उसके फी के या उसका काम भी क्या रहेगा? सो फी वाले जो पार्ट पर है, आप ये कह रहे फी कौन पे करेगा? तो अभी तो यह है कि जो इनिशिएट करता है एप्लीकेशन उसको फी पे करनी होती है. यू आर वेरी मच राइट दैट द अप्रूवल ऑफ दिस COC इज रिक्वायर्ड फॉर द पेमेंट ऑफ फी. तो हाँ, उस पर हम ये कर सकते हैं कि किस लेवल तक की फीस पर अप्रूवल रिक्वायर्ड नहीं होगा. IRP पर अप्रूवल रिक्वायर्ड नहीं होगा, IRP को आपको देना होगा, वो कर सकते हैं. यू आर वेरी मच राइट एंड आई ऑल्सो फील दैट कि जो RP है या IRP है वो पपेट टाइप है कि COC कहे तो कंफर्म हो जाएगा, COC ना कहे तो कंफर्म नहीं होगा. एंड समटाइम्स दे सकम टू द प्रेशर ऑफ द COC आल्सो, क्योंकि भाई मुझे कंफर्म नहीं करेंगे, फिर मुझे हटा देंगे और फिर उन्हीं के अनुसार चलने लगता है. दिस इज देयर, ही इज नॉट एबल टू एक्ट इंडिपेंडेंटली. वो बात जरूर है. तो मेरा अर्थ है कि यहाँ पर जो COC का अप्रूवल है, जो 66% वाला यदि हटा दिया जाए और ये कहा जाए कि COC मेंबर्स रीजन से हटाएंगे, नो अप्रूवल 66%, क्योंकि 66% आते ही वो वोटिंग शेयर लीड बैंक का हो जाता है, वो जिसको चाहता करता है. तो COC में सभी मेंबर्स बराबरी का रोल प्ले करते हैं इररिस्पेक्टिव ऑफ द वोटिंग शेयर. ठीक है, वोटिंग शेयर से 60% होता है, वो हमने दिया है कि वोटिंग के लिए करेंगे, पर यहाँ पर रिप्लेसमेंट के लिए वोटिंग शेयर की आवश्यकता नहीं होनी चाहिए, क्योंकि उसे खराब काम कर रहा है, नहीं कर रहा है. एक्चुअली क्या है, देखिए, द होल प्रोसेस इज मार्केट ड्रिवन Actually, facility has been provided to COC that you are not tied with that particular IRP जो अपॉइंट हुआ है कोर्ट से, आप बदल लीजिए, आपको जिससे काम कराना कराइए आप। तो ये मार्केट को फैसिलिटी लिबर्टी मिली है। अब उसमें ये जो ईमेल आ गई है कि वो अपनी उसमें नचाते हैं मदारी की तरह उसको कि वो कंफर्म करें तो ठीक है, नहीं कंफर्म करें ठीक है। यस, हियर आई आल्सो फील दैट कि रीजंस हटाने के लिए जो व्यक्ति पहले से काम करता है उसको निराशा में, या उसने कोई प्लान कर रखा है कि हाउ विल आई हैंडल एंड मैनेज थिंग्स एंड मेक इट अ गोइंग कंसर्न, उसको अच्छा प्रोस्पेक्ट लाऊंगा, उसने सोचा हुआ है, बट ही इज नॉट एबल टू इम्प्लीमेंट हिज विजन एंड प्लान आल्सो। तो वो थोड़ा सा यहाँ पर मुझे भी लगता है कि 66% वाला एरिया हट जाए और रीजन बेस्ड है, क्योंकि जहाँ परसेंटेज आता है वहाँ रीजन नहीं है। आपने किसी को चुना है सरकार को, वहाँ रीजन नहीं है, वहाँ तो वोटिंग है ना। तो जहाँ वोटिंग आता है वहाँ रीजन नहीं आएगा, इसलिए यहाँ पे रीजन बेस्ड है तो फिर वोटिंग हटा दी। वो भी एक सजेशन आपकी तरफ से हो सकता है। तीसरा आपका है कि क्लेम वाला बात पूछा है आपने कि क्लेम डायरेक्टर अनसक्सेस वाले क्लेम के बारे में पूछा है। अब देखिए पूरे प्रोसेस में, फुल प्रोसेस में मैंने देखा है कुछ माइलस्टोन्स है, क्लेम एडमिशन नॉट एडमिशन, यहाँ जुडिशियस वे से IRP RPO काम करना, जुडिशियसली सब रैशनल कर रहे हैं, एडमिट नहीं कर रहे हैं, वो देखना होगा। खाली आप डिपेंड करें कि वहां से ऑथेंटिसिटी आ जाती है, आयु से तो है ही, वहां तो आप कुछ मना ही नहीं कर सकेंगे। लेकिन जो क्लेम्स है जहां पर आपको डॉक्यूमेंट्री एविडेंस है वहां एक्सेप्ट करना है, पर कुछ डिस्प्यूटेड क्लेम है तो वहां पे एक मीडिएटर की बात है रिजॉल्व करें चीजों को। और जो आप अभी ये कह रहे थे मुझे SCN हो या फाइनल रिपोर्ट हो, ये सब बातें बता रहे हैं, मेरा एक ही मानना है कि यहाँ पर IRP RPO लिक्विडेटर जो भी रोल है, पर वो एक तरह से यदि मीडिएटर बन के वो कन्विंस करे, तो जो आप कह रहे थे कि डायरेक्टर कॉर्पोरेशन नहीं मिलता है, एक्चुअली मोर स्किल इज रिक्वायर्ड। आई मीन IRP को इतना स्किल्ड होना चाहिए कि ही इज एबल टू कन्विंस। मैं सोचती हूँ उसको साइकोलॉजिस्ट होना चाहिए कि वो सबको कन्विंस करके रखे कि आपकी बात सुने, आपको कॉपरेट करें। दैट स्किल इज ऑल्सो रिक्वायर्ड, क्योंकि बिना कॉपरेशन के आप रिजोल्यूशन कर भी नहीं पाएंगे, आपको सारी इन्फॉर्मेशन मिल पाएगी, जब नहीं मिल पाएगी तो आपका सारा समय इन्फॉर्मेशन में चला जाएगा कि वो टाइम पूरा हो जाएगा, फिर लिक्विडेशन कंपनी आएगी। सो IRP नीड्स टू हैव मैनेजर component qualification also, and he should be a keen observer of the human behavior, how people behave and how we can tell। तो उसको मीडिएशन की ट्रेनिंग दिलवाइए, कैपेसिटी बिल्डिंग प्रोग्राम में उसको मीडिएशन की ट्रेनिंग दिलवाइए, ताकि आप परसुएड कर सके अपने डिसीजन को उससे लाने के लिए। क्या होता है कि यदि वो कर पाएंगे तो शायद जो आज कई काउंट पर और कई प्रोसेस से जितने माइलस्टोन हो, चाहे वो क्लेम वेरिफिकेशन हो, चाहे रिप्लेसमेंट कर रहे हैं, वहां भी आप कन्विंस करिए कि नहीं रिप्लेसमेंट क्यों कर रहे हैं और ना कर पाए। और जो SCN की फाइनल रिपोर्ट है, यू आर वेरी मच राइट ऑन द रिक्वेस्ट ऑफ, एक्चुअली हमारे रेगुलेशन में लिखा है अब नए चेयरपर्सन साहब आ गए, चेंजेस करवाएंगे, अब नई रेजिम आई है तो ये रेजिम में भी इम्प्लीमेंट कुछ नयापन आएगा। SCN में फाइनल रिपोर्ट जिन जिन ने रिक्वेस्ट की, मैंने हर एक व्यक्ति को फाइनल इंस्पेक्शन रिपोर्ट दी है, बट बात यह है कि फॉर्मली फाइनल रिपोर्ट है। मैं बता दूं आपको, ड्राफ्ट इंस्पेक्शन रिपोर्ट इज फाइनल की तरह ही होती है। हम उसको ड्राफ्ट इसलिए कहते हैं कि उसको शेयर करते हैं और ये कहते हैं कि यदि कोई गलती से कोई फैक्ट गलत लिखा गया है तो यू कैन सजेस्ट चेंजेस, सो दैट वी कैन एब्रो ओपोनेंट कि वो फैक्ट गलत लिखा है, वो तारीख गलत लिखी, वो फिगर गलत लिखा है, कितने रुपए क्या है, जो भी है। तो मेरा पॉइंट है कि ड्राफ्ट रिपोर्ट इज एज मच एज फाइनल रिपोर्ट, बट वी सेंड टू द IRP और RP जो भी उस कंसर्न लिक्विडेटर है उसको इसलिए भेजते हैं कि ताकि वो ये ना कहे कि मैंने ये बोला था जी आपने ये लिख लिया, तो हम उस करेक्शन के लिए भेजते हैं बस। बाकी फिर भी यदि आप कहते हैं तो मैं फाइनल इंस्पेक्शन रिपोर्ट हम उसका प्रोविजन ले आएंगे, नो प्रॉब्लम SCN में। और जहां तक ऑथराइज रिप्रेजेंटेटिव का सवाल है, देखिए ऑथराइज रिप्रेजेंटेटिव का फंक्शन क्या है, काइंड ऑफ पोस्टमैन, ये है ना, ऑथराइज रिप्रेजेंटेटिव इज काइंड ऑफ पोस्टमैन ओनली। अब ठीक है वो काम नहीं करना चाहता, दूसरा पोस्टमैन आ गया, तो उसमें आप बताइए कि उसके जाने से और रिजाइन करने से और दूसरे के आने से क्या वैक्यूम क्रिएट होता है, या क्या इनएडिक्वेसी आती है, या कहाँ एडवर्स इफेक्ट आता है, वो बताइए पहले। तो फिर आप इसको इसके बारे में सोचें। वैसे तो देखिए वो ऑथराइज रिप्रेजेंटेटिव ऑथराइज नहीं है, वो इम्पोज्ड है। ठीक है, पीपल डोंट ऑथराइज इंडिपेंडेंटली कि ये मेरा है, वो तो एक इम्पोजिशन है कि आपने 3 में से एक चुनना है आपको। तो कभी भी बात बड़ी कंफर्टेबल जोन की नहीं होती है, क्योंकि ही इज नॉट द पर्सन ऑथराइज्ड बाय द होम बायर। वो तो एक आपको चुनना है कि 3 नाम दे, चुन लीजिए, चुन लेते में। अब ये बात है कि जहां तक IRP और RP और AR है, इनमें कितना सामंजस्य है चीजों का, तो ये इसके लिए फर्दर वर्कआउट करेंगे। पर क्या होता है कि हम जितने लिक्विडेशन हम जितने भी अमेंडमेंट लाएंगे उतने हम मार्केट के हाथ बांध देते हैं ना, फिर आप कहते हैं कि हमको तो बांध के रख दिया आपने, तो IBBI ने तो हर जगह बेड़ियां डाल दी है, हम कैसे काम करें, ये भी सुनने में आता है मेरे को। तो ज्यादा इधर रेगुलेशन ओवर रेगुलेशन होगा, तो दैट्स व्हाई आप सामने चीजें लाइए, बेस्ट प्रैक्टिसेस के रूप में आए, कोर्ट विल रिकॉग्नाइज, IBBI विल रिकॉग्नाइज योर बेस्ट प्रैक्टिसेस। पर बहुत ज्यादा ओवर रेगुलेशन करने से भी प्रोसेस मार्केट ड्रिवन भी नहीं होगा और सारी इवेंचुअलिटीज को कैप्चर भी नहीं कर पाएगा कोई भी रेगुलेशन। तो थोड़ा सा ऐसा बताइए जो कि that formulation or that suggestion can cover up the large segment of that sector.
Regarding this mediation and negotiation, मैडम अभी आपने बुलाया तो मुझे एक कैपेसिटी बिल्डिंग सेशन में फॉर मीडिएशन नेगोशिएशन पे लेक्चर देने के लिए, एंड थॉरली एंजॉयड दैट सेशन। तैयारी करके आया तो काफी सारे एक्सपीरियंसेस शेयर किए वहाँ पे। दिस इज रियली रिमार्केबल सेशन एंड कॉम्प्लीमेंट्स टू यू फॉर हैविंग दैट सेशन इन द कैपेसिटी बिल्डिंग प्रोग्राम।
हाँ नहीं, वो देखिए मीडिएशन तो मैं आपसे बताती हूँ कि अब मीडिएशन ही रास्ता बचा है और कोई रास्ता नहीं है सुलझाने का, सिर्फ मीडिएशन ही है जो नॉन एक्सपेंसिव है, टाइम स्पीडी भी है।
Okay, thank you, madam. All the questions which we have received from public, and we have our own question, and the participants they are asking. We will send you all the questions in a crystal manner and dividing into each part that will be there. So Amit, now your turn. So you.
I'll be very brief. I'll be very brief in putting forward the questions and the suggestions. I've heard the Madan sir and other speakers as well. My suggestions are 4, and those are very macro. I'm not going into the micro issues. First point is regarding the increasing number of liquidation cases. Can we do something to arrest that? Maybe I'll not agree with the general market perception that there are large number of cases of liquidation, because the number of cases which have been settled outside are remaining outside the purview of total number of counting of the resolution. So those numbers are definitely not, but still there are concerns. So let us address from where these concerns are coming. The first challenge that industry is facing, there is a complete mismatch, that there are people who are looking for a distress asset, but at the same time they are not able to get the data. Let's say if I'm looking for a pharma company who is working in API, I don't know which all companies should I approach. And IBBI is being a regulator, is the only agency which is well placed to create such type of data pool. Unless and until we create a data pool as to which all pharma companies have gone into CIRP today, and you can go into even micro detail that if somebody wants to identify a company which is manufacturing paracetamol, I can go up to deep down that these are 5 companies which have gone into CIRP and manufacturing the paracetamol. So the person who is the right interested person can go and bid for the same. I think your gap will be narrowed down, because today it's not that many people are not interested. The peoples are interested, but matching is not happening, and they are aware only when the process is either at the liquidation stage or is it already over. That is point number 1. Point number 2, the economic value of the entity which has been submitted to the corporate insolvency resolution process or liquidation process has never been estimated. When I'm saying economic value is different from the fair market value or the liquidation value. Why I am saying? Because there may be a zero liquidation value of an entity, but still that may have an economic value. So the entities which are having the economic value, we need to have a distinction, and the entities which are having an economic value but we are not getting a resolution plan should be parked for some time for a better resolution. Maybe I'm just trying to indicate a concept, a very akin to a bad bank. Can we transfer these entities to an entity called a bad bank type of, where these assets are parked and over a period of time they can be resolved? because you not necessary that everything will come at one stroke. So if I have an economic value, maybe my liquidation value is, let's say, 10 crore, but economic value is 100 crore. Why should I liquidate that unit today? I should preserve that unit and maybe resolve it tomorrow. Point number 2. Point number 3, which I am suggesting, is to separate the process of avoidance transaction application to a separate institution or separate mechanism. Because I fully agree, unless you create a deterrence in the market, what is happening? The ecosystem and the behavior change, what has taken place in the entire country in the last 4-5 years, is because of the deterrence what the IBC law created. The behavior change happened, the settlements happened only because there was a deterrence. Now, if avoidance transaction applications are not getting successfully concluded within the CIRP period, what is happening? People are knowing that you only have to make effort that these applications are delayed and they are not decided till the resolution. And if the resolution is over, your avoidance is also virtually ended. There is no fate to the resolution after resolution of the avoidance application. My point is that let us have a separate mechanism, maybe through IBBI or otherwise, for pursuit of these applications to the logical conclusion. That is point number 2. Point number 3, there are certain businesses which are essential for which the carve out is required. Like, I'll give you the example, like financial service intermediary has been carved out of IBC because they require a separate set of procedure. Maybe we have seen certain cases like DHFL being bought by way of amendment in the CIRP IBC regulation, but those were exceptions. Can we think of creating a carve out for certain class of industries like home buyers, real estate companies? Those are companies for which we have a separate regulation. RERA is there. If there is a problem, you strengthen RERA regulation to bring the problem to the logical conclusion rather than creating a IBC overlapping the RERA provision. It is not correct, and your problem of abundancy of cases before the IBC will be sorted if you are able to do so. Also, we can create exception for certain government companies, as only time is wasted before the adjudicating authority in settling the dispute of these government companies, and it is not logically possible that you can put the state machinery into insolvency. It is next to impossible that ever it will happen. Only thing is that we are wasting our resources. The straight instrumentality should be separated from the process in respect of insolvency resolution. And last point which I wanted to submit is, can we think of, because my experience may be little limited as far as the pre-pack insolvency is concerned. So far, we have not been able to see the success of pre-pack. That is maybe my observation. Maybe I am incorrect completely, but that is the industry perception also. Can we think of in a stage-wise migration of extension of these pre-pack provisions to the other companies also, so that we can have a larger benefit in respect of pre-pack insolvency resolution? It's an excellent concept. It has been conceived well. It has been having a very noble objective. It will achieve success. That is my point, which I just wanted to convey. I think maybe we can separately suggest some more points. Pawan sir.
You're muted.
Thank you, Amit. Thank you for giving suggestion. We will compile it and send it to Manoj. What is your view and suggestion? Then I will quickly you can tell.
Yeah, thank you, sir. I think many of the things have already been discussed. One of the important aspect which I would like wanted to discuss regarding the pre-pack. I think it is very important and very important and good legislation and it can be a very good tool to avoid many of the insolvency situations beforehand, and which will be helpful in realizing the best value for those insolvent companies and for all the stakeholders. So I think gradually this need to be extended to other companies. It is only available for MSME. Recently, many of the cases have already been filed. There may not be many successes yet, but many applications are pending before NCLT for final conclusion. So that is one of the very important aspects. Another aspect I think Mukulita Madam has already discussed, to strengthen the capacity of insolvency professionals. So Indian insolvency professionals, I think insolvency professional entities framework should be strengthened, and it should be allowed that other professionals may be hired, because all insolvency professionals are not equipped and not capable of doing the management. The work of insolvency professionals is not only legal, it is also managerial work, investment banking work. So for that, there may be a need to different skilled people to come together, and for that, I think IPE concept may be strengthened and maybe allowed more flexible. So that can be very good. Then one of the biggest problem in insolvency resolution and keeping the company as a going concern is interim finance. There are certain new entities are coming, like Legal Pay is one of the startup which is focusing on paying interim finance. So such concept should be promoted, and maybe there may be some regulatory changes in RBI law or some concept, a specific kind of NBFC may be formed, which is focused on these things. So I think these are the important aspects which may make the insolvency system more robust. I think we should focus on those things.
Karan, some suggestion?
A small suggestion is there. I think I must congratulate, in fact, firstly, to all the entire machinery which has done a fantastic job to enforce the provisions of the IBC and further the objects of the code. However, we keep listening about the preservation of the value and time-bound resolution. The only thing is that the issues are there before the IBBI. A simplistic view would suggest that some sort of modification or some amendments could be brought to take over the burden of the NCLT, which are practically handling too many cases. Every panelist has practically suggested that there are minuscule issues which are going to the NCLT, and immediately the basic process involves that the application, some notice has to be issued, thereafter reply will come. The entire process is delayed. However, this prejudices the interest and the basic value of which is available to the creditors. So an amendment which can deal with the basic issues which are there before the NCLT would definitely curtail those things. That is my only suggestion, sir. Thank you.
Okay. I think we can, there are some questions. Amit sir, you can also give whether we require a COC, code of conduct also required. Time has come because there are so many issues are coming with COC's different practices.
In my presentation also, address also, little bit I touched upon this COC also. And definitely that law needs to be in place for that purpose also, because we keep receiving issues relating to COC. To a certain extent, we find like we are not well equipped to deal with those COC issues.
Okay.
So another small response to all the suggestions made by your experts. Maybe I would request kindly address this to the government ministry and give a copy to us, because these issues mainly like the whatever has been raised, I think they require amendments to the code. And really we are for it, and any additional responsibility to IBBI will be a very, very good thing to us. We would be happily receiving it.
Definitely, sir.
Welcoming them.
Definitely. So, Madan, there is one question that NCLT decision recently on Springfield Shelters Private Limited. If no resolution applicant other than the existing promoter can give resolution plan, then it defects the entire CIRP. What is your view? Unmute yourself, please.
What is the last question?
NCLT decision regarding Springfield Shelter Private Limited. If no resolution applicant other than the existing promoter can give resolution plan, then it defeats the entire CIRP.
Here comes the question of section 29A.
Yeah.
And per se, if you ask me, I'm not in favor of section 29A regarding ineligibility of the promoters of the corporate debtor unless they are willful defaulters. All other conditions should be done away with, except in case of willful defaulter, they should be debarred. And we have seen number of cases where there are only directors of the corporate debtor in case of resolution plan or in case of liquidation, that they are the only entity who can really take over this company or the assets of this company. If they are also debarred, then certainly there is no acquirer, there is no buyer, and entire value of the assets gets deteriorated. I think there is some rethinking on these provisions of section 29A.
Okay. Manoj, is there any, generally it is, there is one question on carry forward losses. If there are any jurisprudence pertaining with regard to carry forward of losses further, or there are special permission required when the resolution applicant by a corporate debtors only to avail carry forward of losses?
Yes, sir. So in case of closely held companies, as per income tax section 79, if there is a change in control of the company, then there will be no carry forward of losses. In 2000 budget, this section was amended and provision was made that in case of insolvency resolution process, if a scheme is approved and the said scheme is forwarded to income tax and principal commissioner level has scrutinized the same and allowed it, then the carry forward of losses may be allowed. So that provision is there. For other than closely held company, this provision is not applicable. So even in case of listed company, it can be carried forward without intervention of income tax.
Amitji, there is a question relating to this. Why not partnership firm or companies not in the form of IPE, but are having all the essential of an IEP permitted with a pool of professional consisting of CA, CMA, CS, IP advocate, IP bank, retired and IP from corporate, with the industrial experience and domain expert to perform the CIRP and liquidation, just like performed by IP. Is it any things going on in the mind of regulator?
These questions keep coming to our mind also. Because I come from SEBI, you know that we were against the individual brokership and we converted a brokerage into a corporate also. Yes. So that question keeps coming. And you see that this code does not prohibit corporate, but says the person, any person can be an IP. And you know the person's definition is quite extensive and wide. But the thought process, I think that is flowing from the Bankruptcy Law Reform Committee, that IP needs to be individual. So regulation has restricted that eligibility criteria. I think maybe it may be influenced by some international experience like UK. See, there are individuals, solvency practitioners. So I think to just fill some gap, the IBBA has created this entity like IPE, Insolvency Professional this entity. So they are not IP, but they provide support services to the IP. And I think idea behind that IP is really like just plugging in some gaps. And I hope that there may be some shift also that happens. We will come out with some discussion paper on that.
Okay. Amit, should IBC company file its NCA form directly or in GNL1?
There are two ways to look at it. The forms where there is no restriction, like there is a misunderstanding that when the company comes into CIRP, the director seizes. It's only the power of director which are seizing. So there can always be a key managerial person. There can always be a company secretary. There can always be a CFO. There can be a manager. There can be a managing director. So if these peoples are on the company board and they want to file the form, so they can file the regular form. Now, GNL form was introduced in the situation to meet the exigencies where these professionals are not there and only the resolution professional is there. How to comply with that? So the law provided that you can use the GNL form where as an authorized signatory, your signatures will also be allowed. So GNL form is just a stopgap arrangement where you have a company secretary. The companies are using the signatures of their authorized signatories for the purpose of filing their respective form. GNL is not required to be filed. GNL is the exception.
Okay. Karan, does the RP require to hold AGM if the company is in CIRP?
But there has been a circular by the IBBI to meet the compliances during the pendency of CIRP as well. And of course, the approval of accounts is required. So that is the requirement of the law.
Amitji, many registered insolvency professionals do not have assignment for months together. How can be this addressed? Please throw some light.
This is an issue with every profession, if you see. Not just all the stockbrokers are earning, like say that not the doctors, all the doctors are earning. It's a profession which requires some competition, and then competition can only if somebody is competing well,
Okay.
and he will take the front seat.
May I answer this question?
Another thing which IBBI has done something, I want to just brief you. In the code of conduct, we have tried to just deal with this issue, where we have said that an IP may not exceed the 10 assignments. The word used is may. You know that you are all legal professional. You cannot put a ban to a profession. The moment if we use the word shall, people will run into the writ jurisdiction. This against a profession, right to profession. So no profession, I think, if you can give some example, can put a restriction to the employment by a regulator or even the government. You will not do, say, like I say, doctor, you will not perform more than 5 surgery a week. Doctors are performing sometimes overnight surgeries also. That type of restrictions, that is in place.
Correct.
If you have a better suggestion how to spread it, please, this is the way out.
Madan, there is one question which is asking by lawyer from the lawyer. Unfortunately, in any IBC case, the first point of initiation from a company goes to the civil lawyer, some of whom are entirely new in IBC law. These lawyers, in order to do not lose the client, hold on to the client without referring.
I've read this question, and it is very unfortunate. I've seen a number of cases. Some of the cases, the applications are admitted because of this reason that the parties are engaging certain lawyers who are not well versed with this legislation. And this is really unfortunate part. I think when Mr. Amit Pradhan also talked about justice, surgeon and all that. But then this is a specialized field, and every stakeholder is expected to go to a specialized professional only. If they are not going, it's their fault. And because of them, the cases are being admitted. It is very unfortunate.
Okay, Manoj.
Just to add, sir, I think because we are talking, there is a need, although IBBI has been doing a lot of hand-holding by way of reaching out to different offices, including like I've been part of the income tax training program. They are going to the corporate training program. So, but this all needs to be even furthermore expanded so that the corporates really understand what is the length and breadth of this regulation. Even after 5 years, people are not understanding what is IBC, then that is a really time to introspection for us also.
Okay, but Manoj, in the case of MSME company, if no one else can participate, creditors have to accept what the promoter offer. This is the intention of IBC? Quickly.
It is not the intent. I think they can reject the proposal of promoters and company will go into liquidation.
Okay, Amitji, there is two questions from you. Now, what is happening that we have seen the investor of listed companies. Now, if listed companies is coming because you have experience in SEBI, they are in the IBC process. Now, the question is, I can give you the name of the various companies. As a shareholder, as an investor of market, I am not aware whether this company will be listed or not. Take example of Bhushan Steel, Tata has taken, the Ruchi Soya, the Patanjali has taken, JP Infra, the issue is not clear what will, Orchid, and then various other companies on DHFL. Now, if you see these companies, then their trading is taking place in market with this hope that this company will be listed or somebody will take over. But actually, out of this some company, they are not going to list because they have decided to delist the company, but this information is not coming to the investor. So my point is, why IBC is not providing that when they are submitting information or resolution plan is there, suppose there are 3 resolution applicants, then they should ask, because other thing you are saying it's a confidential, but they can say their intention that after this taking over company, I will continue to list. Whatever the reduction of capital will take place, I'm not bothered about whether I will be listed or delisted. That is a question. So the point is, you are not providing anything to the investor shareholder, but at least the new investors should not come into trap. DHFL we have seen, JP Infra is not clarity whether it's list or delist, and the highest number of volume is taking place in the market. What is your take on, sir?
This issue is more relating to SEBI only. If that entity is already listed, so delisting regulations will come into the picture. So that rules, that regulation provision will have to be followed. So your issue is that the investors or maybe the prospective investors, they are not aware of the intention of the company.
Yes.
Whether they are going to continue or not continue.
Yes, sir.
So that is I think the one of the condition. I think that should be there in the resolution plan and their intent to how to run this company as a going concern.
No, going concern and sir, listed company, both are different things, sir. So that
Yes.
is, yeah. So my suggestion is, IBC should put this condition that you don't disclose all other things, but disclose this.
Sir,
Yeah.
I believe I'll just add to what Mr. Pradhan was addressing. I think SEBI has already addressed this issue by way of 7th July 2021 circular. So they have came out with the guidelines very clearly asking the resolution professionals to inform as soon as the resolution plan is approved and it provides for delisting of securities or continuance of securities where the public shareholding will be falling below the prescribed threshold.
Amit, my question is different, because I am the person who is from the capital market. I have seen this. This is very clear. I'm saying till the time resolution plan is taking place, the market is listing companies taking place. The only thing is you put only on the stock exchange side that IRP stays 0. Okay, you write this. That's all. I'm just asking, the investor is trading today also, tomorrow also, between the resolution plan also. So I don't know whether this company share which I'm buying will be 0 or it will have some value.
Yeah, I was just addressing that only because SEBI has taken a stand. We will continue to allow the trading till the time a resolution plan decides a delisting.
So that is okay, but the resolution applicant is planning to delist. That should be known to the investor. Today, I, as a shareholder, if plan is going to the IBC, I will not get anything if the shareholder, because there's no list, there's no sequence. But the new investors are also trapped in this. That is the.
I agree that needs to be considered for.
You were saying something.
So what is the point? Suppose the promoter, that RA says the company share will remain listed, but simultaneously proposal is here that 95% of the existing capital will get extinguished.
Madan, I have no problem in this. I have no problem in this, because everybody is taking haircut. They are also taking, NCLT is taking call, but listing is there. So that 5% share, which is 100, earlier it was 100, now it's become 5, will get the same value after some time if the resolution is taking a shape.
My view on this is, after the approval of the plan by the committee of creditors, the resolution plan should be in public domain, so that any stakeholder who has any issue may file his objection or may take a call whether he should continue with the company or not.
Amit sir, we will, all the suggestions which everybody has given and we have received, we will send it to the IBC, and we will divide into IP related, regulation related, all these things. So you can have a call, because these all are the people, day and night. Karan is standing in the court always, relating to this IBC, listening to his case also, and arguing his case and listening to others' case. Amit is also advising. Madan is always in the court, and Manoj is restructuring. So these are the people who are really facing, and whatever questions we have received, some of the questions already was there with these people. So we have tried to collect all the things and we have given you. Now, thank you very much. We are overshoot the time prescribed this. Though we have a various other questions also which we have prepared if something important, but we will send it to you.
Sure.
This 2 hours is not sufficient. It requires full day for discussing each and every topic. But because our program is like a capsule program and Q&A, and today is the very great day that all the three regulator of top regulator of the Insolvency Board they have come and they have given their mind. The only one thing is very clear, that you are adaptable to change. You want suggestion, you want to improve it, you want to discuss with the public, and you want to bring this message. We are open. And interestingly, Madan has said the right point. What Seniji has said, what you have said, and what Madam has said, you all are aware of the entire issues. Only thing is there is some legal point, but as a professional, as a influencer, we want to compel regulator that this is the problem of the industry. Please fix this problem. It can give a better result. So thank you very much to all. Before starting, this is our normal practice that we are asking 1 minute from relating to law. What is their view? So Amitji, I will start from you, that where you want to see the IBC, and then we'll close this program.
I want to see IBC as the top regulator of the country.
Okay, Madan.
I'm very bullish about this legislation, very optimistic about this legislation. The way this legislation is being implemented, I'm of the view, barring willful defaults, other defaults will be history, and there will not be any defaults in our banking sector, in our corporate structure.
Okay, Amit.
So distress asset is a reality. If a business is there, risk is there. Risk is there, so distress will be there. So if distress is going to be there, so a resolution of distress is a solution in IBC. So that is also going to stay.
Okay,
I'm very positive.
Yeah, so I think everyone has said well, and it is very important legislation, and IBC would continue, and it will create. Obviously, it has created a lot of deterrence, a lot of discipline in the financial market and corporate world. So it will obviously achieve its purpose. There are requirements of modification. Ecosystem is still developing, so it will develop and it will create very good system in the society.
Okay, Karan.
So the IBC could be and has been the game changer for the resolution of the stressed assets in the economy, and I'm sure that in the coming years it will perform exponentially.
Okay, thank you very much to all, and thank you. Because I have a privilege to say the last word. I remember Mr. Sahu was always saying, this law is the best use of this law is not to use this law. So the point is, this one sentence talks about the change in culture, change in mindset, and thinking in a different manner, that public money is not a money which is my own. That is a fear which has come, and no doubt we have seen. We were the part with the Tata Steel in the Bhushan. We have seen this a lawless coup. This is bloodless coup, which has taken place, one management to another management without any doing anything. Thank you very much to all. My sincere thanks to Dr. Navrang Seni, because he has a AGM somewhere, but he has participated. Thank you, Muklekta Madam and Amit Sir, on behalf of entire professional, those who have come today. We thank you. Thank you, Madan. Thank you, Amit, Karan, and Manoj for participating. Friends, the same knowledge sharing initiative will continue. It will not stop. So on next Friday, we are having a very interesting topic on Data Protection Act. And Pawan Duggal, who is the expert, who is the person, and who is a honorary chancellor of Ranchi University of Cyber Law. He will be the person who will interact with us. And I hope that Data Protection Act is not only connected to the cyber law only. It is connected with everybody. Even regulator, Amit Pradhanji is doing something that is connected. Madan is doing advocate work, is connected. So today, Manoj is advising, Karan and Amit, whoever is advising, they should realize this, that this is the important legislation where we have to understand in whatever we are taking, whatever we are using, are we violating any law? So this program will be a very interesting and applicable to all. I thanks everybody, and especially my thanks to all participants, those who have come. And my announcement, anybody wants this book, they can write to us, and on a very special discount, whatever we are getting from the regular publisher, we will give it to you. And all my fellow speakers, they will get complimentary copy tomorrow. Thank you very much. Thank you.
Thank you, everybody. Thank you.